bottamento ಅಂತ ಕಾಣುತ್ತೆ.
It's one matter, my lord. I just say an expert section 9, my lord, ex parte injunction was refused, my lord, commercial. The day-to-day activities being preventing by the my lord, it's a developer company. They all people coming and sitting in the office, my lord. It has been refused for 2:30, my lord. There's some urgency because my lord, say they also.
Any mentioning? List 1.
May I submit before then? It moved the memo for posting. It was directed to be listed today. It has gone to the board branch, but it has not been listed.
Yes.
Tomorrow, my list.
No things. Don't be hate.
Serial number 3, my lord.
List 1, page 1, seal number 1, page 2,
Serial number 3, my lord.
213.
Start for 3-4 days accommodation. Clarify the office objection. Rectify the signature and translate copy. So far, I start for 3 days accommodation.
Don't worry about the
Please,
station. The issue of rectification.
please.
Rectification on the basis of a decree.
No, my lord.
Yes,
Not
of a
only,
past decree.
not only rectification.
79. Yes.
That is not rectification, my lord. The suit filed by the
In
declaration.
fact,
injunction.
most of the documents I have provided along with my appeal.
Never mind the translation. Whatever else, what else is the observation?
Only then office objection raised by the office bearers, translate copy 1, and also send the
The
suggestions.
objection statement apparently is not being signed by the council.
Rectify. Yes, 3 days time for rectification. Yeah. Translation. Yes.
Date may.
Whatever is relevant.
3 days accommodation.
In fact, most of the documents it may be dispensed with because I have filed the translated copy.
3 days accommodation.
Please,
17:9.
please, grateful.
Page 3, 4 to 8.
Sorry, my lord. 79.
I beg to take a mention in serial number 8. I appear for the respondent number 1 and 2. Council on record is.
I appear for it.
He's also intimated the council. Please grant some.
The date could be fixed because there's an urgency.
Please agree on the date and tell us.
17th. 17th if it could. Obliged.
Page 4, 9 to 14.
Serial number 14, my lord. Appearing for the appellants. Parties are in mediation. My lord. Parties are in mediation.
I mean, from the other side,
No, my lord.
please, when you're seeking adjournment in contested matters, from the other side. Otherwise,
I will.
please inform them from the court officer of say on the agreed date.
Sure.
Yes. Page 5, 15 to 17.
I'm appearing for appellant in serial number 15, your lordship. Senior is not keeping well. It may, yes, your lordship. It may be taken up next week, your lordship. 15, 1.
56, 7, 2012. And RFA 280.
Yes, your lordship. Yes. Yes, that is what is there. It may be taken up next week.
30th. Yes. Yes.
Date can be fixed, my lord, we can go on to matter.
Yes. 14th October. Yes. October. Page 6, 18 to 21. Page 7, 22 to 25.
22, my lord, seeking for short accommodation, my lord, during next week. I have informed the other side. Yes, I have informed the other side. During next week, my lord, 18, my lord, it could be taken.
23.
23, 9.
9.
Please. Great.
Disability count to be 30%. Yes.
Serial number 25, my lord. Serial number 25. Yes, ma'am. I'm for appellant, my lord. ಸೀನಿಯರ್ಗೆ ಹೆಲ್ತ್ ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ, ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾರೆ ಇವತ್ತು. 1 ವೀಕ್ ಆದ್ರೂ ಅಯ್ಯೋ ನಮ್ KD ಬಿಂದ ಅಮೌಂಟ್ ಬರ್ಬೇಕು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾವು ಪೇ ಮಾಡ್ತೀವಿ. 1 ವೀಕ್ ಆದ್ರೂ ಟೈಮ್ ಬೇಕು ಸ್ವಾಮಿ.
Last time they didn't inform us at that time.
Next week.
17. Page 8, 26 to 29. Page 22, so number 53 and 54. Page 23, 50. Page 24, 55 and 50 to 57.
Since the states are dated. 2019 and 8. Please be ready on the next date, please. Yes.
30th. Page 25, 58 to 60. Page 26, 61, 62. Page 27, 63, 64. This one, preliminary hearing, seal number 1, Vijay Radhasan.
Sling madam.
Jana,
Please, ma'am.
one
Uh,
submission before Puji. Despite the order of this honorable court, they have made a transfers on just 4 days back. 44 medical officers have been transferred. Despite there is an interim order. Because today morning I got it, and that is the reason why I couldn't provide the translation copies. This is dated 3/9/2024. Medical officers.
Next round of counseling would be deferred, but in the meanwhile, if there is an extreme emergency. and, some orders are-
No, this is not an urgency. That is the reason which.
No, I'll
Please.
just, my lords, off the cuff instructions. Immediately I got instructions that, my lords, there are certain posts which are outside the act, provisions of the act. It is not the commissioner, my lords, who has passed this order. The government, my lords, is entitled to make those transfer orders. In fact, it is a government notification which is in respect of posts which are outside the act. That is administrative post. It will not come under the purview of section. Now, my lords, we have proposed 2 solutions to the matter. My lords, there is one memo along with the act and the rules. That one may kindly be taken. And my lords, the WP number 23468 of 24. Lords. ಇಲ್ಲ, ನಿಮ್ದು writ petition. Lords, in that, annexure A4, my lords, at page number 104.
Yes.
My lords, at page 108, my lords.
Yes.
In view of the order passed by the Honorable, serial number 4, my lords. In view of the order passed by the Honorable Karnataka High Court in WP number so-and-so as per its order dated so-and-so, the medical officers who are arrayed in the mismatch list prepared on so-and-so as per section 5, they're entitled to participate and given opportunity to opt for the vacant seats in the counseling of public interest transfer notified list issued under section 6, and the said medical officers who are in mismatch list have to be given priority to opt the vacancy notified during the said counseling before commencing the counseling for medical officers who are being transferred in public interest. This, my lords, we are agreeable to hold it as a one counseling. We are agreeable for this, so that the grievance, my lords, of the petitioner is met. That is 1. 4, 6, I'm coming. First part, it's a common counseling as per senior.
We have objections for it. That is the thing, my lord. My IA could be considered. I may.
Please. Then insofar as serial number 6, my lords, for the preparation of transfer list under Public interest as per section 6. All the medical officers who are working in Bangalore urban district jurisdiction, the total working period is to be considered as Bangalore city, irrespective of whether they have served in the single government hospital or institute or two or more government hospital or institute. Now, my lords, I want to take my lords to rule 6 and rule 10 for a moment. My lords, rules, my lords, we have, no, my lords, rule. This is a government order, my lords, which we issued. Now, kindly see the rules, my lords. Sir, rules.
Got it in page 81, section 6. In the repetition itself, I find both rules and
81 at 87. 85 rule starts.
Start with section 6. That is the.
I'll finish. Minutes 87 may kindly be seen. Rules 6 minutes. Transfer of medical officers and other staff. A medical officer or other staff who has completed the minimum number of years of continuous service in a government hospital or government institution as specified in the table below may be transferred to any other government hospital or government institution in the same area or zone or to any other area or zone. Kindly note this, minutes. Then we have given the table. Now we are only concerned, minutes, with group A, that is 3 years. Minutes, only for the purpose of this section, minutes, since that clause applies with regard to Bangalore urban district. Now kindly see, minutes, rule 10 for a moment. Rule 10, my lords, is where the grievance lies. Preparation of priority list. All the verified applications shall be arranged in the following order of priority, namely, terminally ill cases of serious ailments, persons who are due to retire on superannuation within 2 years, cases of physically disabled with more than 40% of disability as certified by the district medical board, cases of widows, case of husband and wife who are government servants and whose cases to be considered as per provisions of transfer guidelines issued by the state government, other staff. Explanation, my lords, I will skip. Kindly see 2, my lords, for a moment. Within each of the above priority categories, kindly note this, my lords. Within each of the above priority categories, the priority list shall be prepared by multiplying the number of years of service by the applicant in all cadres in the places classified as Zone A, Zone B, and rural area by the weighted ratio allotted to the respective zones as specified below to get the weighted service in years. Zone A, the completed number of years of service rendered in all cadres in Zone A into 1 point. Zone B, the completed number of years of service rendered in all service in Zone B into 1.50. Rural area, the completed number of years of service rendered in all cadres in rural area into 2. The staff with more weighted service shall be considered above the staff with lesser weighted service while preparing the priority list. In case of tie, the seniority of individual shall be taken into consideration. In case of tie in seniority also, the older in age shall be given precedence. The competent authority shall prepare the provisional priority list as explained above, and same shall be notified in the notice board and on the departmental website inviting objections within a period of 7 days, if any, from persons likely to be affected thereby. Immediately after the due date from receipt of objection, all objections received shall be considered and the priority list shall be finalized. Now, for the purpose of clause 6 there, my lords, rule 10 is not affected. Rule 10 will be applied as it is. The points that have been given here will be applied. Bangalore rural district, urban district, we are not touching. Please, my lords. No, my lords, the clause 6 applies only qua rule 6. Only qua rule 6, only for the purpose of long standing. There, my lords, we have an option because the word used is same area or zone or to any other area of zone. So there, Bangalore urban district, my lords, is taken as a whole. Because Bangalore urban district, my lords, consists of all 3 zones, and my lords, all we have to move out, my lords, long-standing people from out of Bangalore district. That was the purpose. So therefore, my clause 6 in the government order will not violate any of the provisions of the act. Their grievance was with regard to rule 10, that priority list will get violated by using the word Bangalore urban district, which consists of all the 3 zones. I might lose out certain points. We are saying that, my lords, rule 10 is not affected. I have not referred to rule 10 in clause 6. I have only referred to rule 6. So only for that purpose. Kindly see the government order for a moment now. Page 108. Please.
There is a mistake, not rule. It is section 6. Section 6, not rule 6, section 6. They have quoted rule 6.
Allala, our translation is wrong. Milords,
This is section 6.
When is saying rule 6. Page 81 is the section 6. If it is the section 6,
So section 10 will not be affected.
section 6, the executive order, let my learned friend complete. If you go by the executive order, the executive order speaks contrary to section 6. That's the principal ground which I am.
Milords, in the Kannada version, Clause 6 refers to rule, not section. Translation, it is their translation. If page 102 may kindly be seen, it says Niyama Aru. Translation refers to section 6. So therefore, my learned friend is alleging that it is in violation of section 6. But I have referred to rule 6. Rule 6, my lords, only talks about minimum tenure. And for that purpose, my lords, for long-standing purpose, I am using the my lords, the Bangalore Urban District. Rule 10 is not affected. Translation, my lords, uses the word section 6, which is incorrect translation. It refers to rule 6 itself. So section 6 has not been violated at all. Rule 6, only for rule 6, my lords, that clause 6 applies. And rule 6, I have, my lords,
What is section 6?
my lords, section 6, page 81. A medical officer or other staff who is in service on the date of the commencement of this act and has completed the prescribed number of years of continuous service in any government hospital or government institution in an area or zone may be transferred through the process of counseling, but given priority to persons put in longer period of service in that area or post, and considering such other criteria as may be prescribed to other government hospital or government institution in the same area or zone, or to any other area or zone in the following order, namely rural area, zone B in urban area and thereto, and zone A in urban area, provided that the total number of transfers during the year shall not exceed 15% of the number of working strength in that cadre. So this is public interest transfers. So it is, please, madam. Please, madam. Section 6 is the entire public interest. Rule 6 and 10 both subsume section 6. But in the steps, my lords, that we are referring to, my clause refers only to rule 6. So there is no violation of rule 6 by virtue of my clause.
Yes.
Please, my lords. So therefore, my lords, my respectful submission is we may be permitted to go ahead with the counseling. Any which way, my lords, we have to announce the priority list. And if there is any issues with regard to the calculation of the points and other things, they can file objections. And my lords, on the last date of hearing, I had passed on, my lords, the amendments with respect to critical vacancies and other things. That, my lords, will follow any which way. And all the vacancies, my lords, that are available under the mismatch category, everything will be across to everybody, including the cricket. We have last time, my lords, their allegation was critical vacancies were notified after we entered the hall. We'll ensure this time that all critical vacancies are also notified in beforehand, and let them participate in the second round of counseling. Is my respectful submission.
My learned friend has read out rule 6 cut off section. Request the original 101, the Kannada version.
Yes.
Page 101, annexure A4, using data. Point number 3, section 6, not it. Section 6 of the Karnataka State Civil Service Regulation of Transfer of Medical Officer, other staff Act 2011 states as follows. The transfer of medical officer and other staff in public interest. A medical officer or other staff who is in service as of the date of commencement of his service and has completed the prescribed number of years of continuous service in any government hospital or government institution in an area or zone may be transferred through process of counseling by giving priority to person put in longer period of service in that area. Because this word, what giving, they have highlighted in this law. Longer period of service in that area or post, and considering such criteria as may be prescribed to the government hospital or government institution in same area or zone or any other area or zone in the following: rural, zone A, zone B. Further, provided that the total number of such transfer during year shall not exceed 50% of the number of working strength in the cadre. Next is very important. Further, as per GOT text so, the mutual transfer are not contemplated for Bangalore urban district. Now, I request your lordship kindly come to 6. Clause 6, I am very permitted to read the English version. The reason why I have said section 6 is because if you read that without section 6, it is one and the same. Now they say the service what I have entered in any hospital, what we are contemplated under section 6, whether government institution, hospital, that in urban, Bangalore urban will be accounted for the purpose of. No, it's not section rule 6, it's section 6 only. Now, my learned friend is trying to interpret in section rule 6. That also I will convince you lordship. Kindly see 108 for point number 6. For the preparation of transfer is under public interest, 108 you lost, the translated for preparation of transfer list under public interest as per section 6. All the medical officers who are working in Bangalore urban district jurisdiction, their total working period is to be considered as Bangalore city. Now within inverted comma, within bracket, they say, irrespective of whether they are served in single government hospital, institute, or 2 or more government hospital institute in Bangalore. Now we also kindly come to what I read in page number 101. Section 6. A medical officer or other staff who is in service as on the commencement of this act has completed the prescribed number of years of continuous service in any government hospital or institution or in any area zone may be. This is extracted here. It is not rule 6, it is section 6. Ah.
Yes. Or road or to any other area of service.
So it is section 6. Now I request your lordship kindly come to rule 6, in which my learned friend are. Page 87.
Yes.
Rule 6 in which matter, transfer of medical officer and other staff. A medical officer or other staff who has completed the minimum number of years of service, continuous service in a government hospital or institution as specified in the above below, may be transferred to another government hospital or government in the same area or any other. It is not contemplated with regard to public interest. Public interest is only section 6, in which now, why rule 6 is decided? Suppose if a medical officer completed the minimum tenure, 3 years in a particular place. If I am not come within the ambit of 10 years of continuous service, then if I am not satisfied with the present working area, after completion of 3 years, I may be permitted to make my application after completing this minimum 3 years. Whereas if I completed 10 years, continuous, I have that you lordship get it in page 77, amendment. Amendment Act 34 of 2007. There are number of officers and staff who have completed 10 years of service in same place. In order to transfer them in public interest, them in public interest is considered necessary to increase the 5% of transfer of medical officer, other staff 15% by amending section 6 of Karnataka State Civil Service Regulation Transfer. So, what my reading is, rule 6 has no application to this case. Because while by issuing an executive order, they are keeping in mind of section 6 only.
Yes.
Now, with regard to challenge to the executive order, more particularly since my learned friend has considered with regard to clause number 4, I have no grounds against that. So far as 6, whether that is permissible for through an executive order to give effect entire Bangalore urban district as a one unit. I request your lordship kindly take the definition clause of medical officers. 79.
29 is the
Page.
amendment.
Definition, page 79. 2G, medical officers means medical officer appointed by the appointing authority to any of the category of posts specified in Schedule 1. I request your lordship kindly come to Schedule 1 now. That is, your lordship get it in page 83. Schedule 1, senior specialist, deputy chief medical officer, everything is considered as a medical officer. Now, if my learned friend argument would have been accepted, if they taken Bangalore urban district as a one unit, then it has to be state as a one unit under the definition. There is no classification for Bangalore separate or any other district. In otherwise, if an executive order has to be given effect, it cannot be given effect only for one urban district.
Urban area means any area.
Urban area means any area situated within the limits of city corporation, city municipal council, town municipal council, town panchayat, other notified areas specified under the Karnataka Municipal Act, and up to such distance away from the limits of the above area notified of such government from time to time. Zone A next. Means urban area within the limits of city corporation or city municipal corporation at the headquarters. Now the distinction made in zone B is, if you not it, means urban area within the limits of city municipal council which is in place of other than district headquarters, or a town municipal council, town panchayat, and area notified in urban. Now I will stop for a moment. I will give the explanation. If this interpretation of Bangalore urban district is taken as one unit, in Bangalore urban district there is a 5 taluks. So 5 taluks, there is a 5 general hospital, taluk hospitals, which comes under the purview of zone B. If I completed 10 years of service in zone B in Bangalore, then I will come under the purview of this. Here, if I completed 5 years in zone A, in one of the place, in 5 years in zone B, that cannot be considered as a continuous years of service for the purpose of section 6. Now, by giving effect the executive order, they say irrespective of whether I worked in rural area, because beyond the taluk headquarters, all PSC will be considered as the rural area. So each has its own relevance for the purpose of continuous services. Now, what they have done in executive order only for Bangalore is whether irrespective of fact whether I worked in zone A, zone B, or rural area, all service will be accounted as for the purpose of Bangalore urban district as a 10 years continuous service, and I have been incorporated here. This is done only for Bangalore urban district. Now, I request your lordship kindly come. Apart from that, what is the lacuna in this executive order is a person who is eligible for mutual transfer is available for me once in my lifetime or service period. I have no other choice. Once I opted mutual transfer, then my chance to go for another mutual transfer vanished. However, by executive orders, they said those who are in Bangalore urban district, we are not providing the mutual transfer. Your lordship kindly take rule 12. I request your lordship kindly take rule 12. Page 90.
Yes.
Because I just read out the executive order where they say there is no mutual transfer for mutual transfer. Application for mutual transfer of medical officers and other staff may be considered subject to satisfy the following conditions. Namely, both the staff shall together make a specific request in writing of mutual transfer and also agree for the same employee. Both the staff shall have completed their probationary period, it shall be so declared. Both the staff must have completed the specified minimum period of service in their respective places. Both the staff must have completed the specified compulsory rule service if applicable. While considering the mutual transfers of specialists or senior specialists, care shall be taken to ensure no mismatch of specialization happens as a result of such transfer. Mutual transfer shall be done only in month of April, because this year they have extended further. 3 is very important. Mutual transfer shall be allowed only once in one service. However, the same 2 officials who avail such facility cannot interchange their position to second time. When I got an eligibility under Rule 12, fulfilling, on what basis through an executive order, the rule has been taken away. There is the 2 issues here. This is done specifically for Bangalore urban district, I don't know. They have continued, they constituted continuous of service irrespective of the service which they have rendered in any other place for the purpose of that. Apart from that, I am deprived to seek for mutual transfers, which is my right provided under the.
Yes.
So this is beyond his competence.
I understand. Yes, what is your proposal?
My petition 1.1 could be, 1.2 could be taken. 2 IAS I have filed.
Before my turn. If in the absence of executive order, what is contemplated here, if they follow, I have no objection. That is what the tribunal.
It has to be recorded in the act and the rules, cannot go beyond it.
Take for a moment.
Please.
What?
Cannot hold
No,
up.
I am not voting. I am not.
It has to-
Yes, I am ready.
Yes, it has to be in
Your lordship.
the act and the rules.
Only
Please.
one person.
Stated in the-
Please,
Page 40.
I bow down.
Why and before this honorable court, the tribunal considered my case and directed to court in accordance with the act and rules. Nevertheless, they have not taken the executive order, because now, for purpose of executive order, because all the medical officers who are working in Bangalore urban district, they have discharged in various places. That service cannot be accounted.
Yes. What do you see?
IA could,
That's why the tribunal only said. That's the.
as per the provisions. We agree for it. We agree for it and
Cannot, we can't consider how much is to be done. We only proceed to say that it has to be as per the annual rules, whatever the executive order says. Nothing in the executive order can act against the annual rules.
please, Manoj, that is what I want. Please. No, we are okay with the counseling. Please, please. My IA may be looked into.
In pursuance to this executive order, they have notified the list provisionally. In that case, those who are working in Bangalore urban district, all the service accounted one there. If not, that has to be.
Consider, yes.
Please, my IA could be looked.
Number,
18980, the IA dated 26 July
Number.
2024.
3 of 24, in pleading.
IA 4 of 20.
Yes.
Lordship, the reason and background in which the mismatch group was provided an opportunity by for the subsequent participation into the public interest transfer is that the day one which we argued is that we were not being notified all the vacancies. That is what, and they have not done. That is the reason why, based on the equity, this honorable court considered that, yes, you will be provided an opportunity to participate in the further rounds of counseling. No, I am not telling about the, I'm not on the preference.
Yes.
Please, madam. Kindly, Your Lordship, please peruse my IA number 4.
Yes.
Annexure J, my lord, at my prayer at page 14 of my IA. Only 2 lines, madam. Page 14. Wherefore the reasons stated above, small last para. The humbly prayed thus to hold or declare the mismatch counseling held on so and so is ultra vires and consequentially declare the transfer orders issued by Chief Administrative Officer as null non-est. The reason why I am insisting on this particular prayer is that, my lord, page 38 is the annexure J. This is the transfer order that has been issued. The translated copy is at page 39 and the relevant portion is at page 40. It has been signed by a Chief Administrative Officer. The objection that has been raised by my learned friend is that, one, it has been delegated. Your Lordship could now peruse the rule that is being prescribed, Rule 3 specifically. Rule 3, I have placed it before Your Lordship, the Act and the rule. Rule 3. Rule 3 says that the competent authority for transfer of medical officer and other staff is being shown below the table. Rule 3. If I may be permitted to give.
Yes.
Please. Commissioner. Here, the transfer order is being conducted by the Chief Administrative Officer and the transfer orders is been issued by the Commissioner. I would like to rely upon the Honorable Apex Court judgment in this regard.
Yes.
Lordship, page 57, para 20. In that, Lordship, last but 4 lines. It is the settled principle that when an act prescribes a particular body to exercise a power, it must be exercised only by that body. It cannot be exercised by others unless it is delegated. And this is very important. The law must also provide for such delegation. Nowhere in the act, nowhere in the rules, it provides any such delegation of power. That is. Now, if Your Lordship could come to page 72 of the judgment, Apex Court judgment, para 26. May, my lord. it is also well settled that if any decision is taken by a statutory authority at the behest, very important, my lord, or on the suggestion of a person who has no statutory role to play, the same would be ultra vires. Now, my lord, my specific allegation is that the critical vacancies were produced by this chief administrative officer when I enter into the counseling. Even, my lord, the amended regulation also mandates that it has to be notified in the website. That is not been done. This is my specific, and my IF5 could be taken up, your lordship. My IF5, which I have filed on 29 August 2024. And in this page 11 is my prayer.
Yes.
Wherefore, last paragraph. Wherefore, for the reasons stated above, it is humbly prayed to this honorable court to declare or hold para 2 of government order so and so, fixing 5% limit, subjecting the medical officer to the process of counseling as ultra vires, and consequentially direct the respondent to fix 15% limitation in subjecting the medical officers for the process of transfer by counseling as contemplated under section 6 of so and so act. This is my specific observation for the reason that 15% means, my lord, if 5% means only 150 officers will be subjected. If it is 15%, 450 officers will be subjected. And this counseling is been taking place after almost 8 or 9 years. That is the reason why we will get an ample opportunity as per section 2I of, because I should be provided an opportunity, and the opportunity based on my length of my service. That is what the specific observation of this honorable court in this.
Please, Manoj. Want to say something?
Just 2 minutes.
Yes.
I just have 2 respectful submissions, well, your lordship. I had filed 2 IAs, one with respect to transposition and the other with respect to impleadment. Transposition on the previous occasion, my IAs may be allowed, especially with respect to the transposition application. The only reason why I was not able to be as on the other side as a petitioner is because I was not able to sign. However, I was very much a part in before the KAT, my lord. And as far as the impleadment application is concerned, few of the applicants in the IA were part of the proceedings before KAT. Only few of them were not. So that is my respectful submission. I'm grateful.
Manoj, with regard.
You find what? Transposition.
Impleading, yes.
Please, Manoj. Impleading applications can be
Please,
allowed.
please.
Because we have
Please.
already said that Lord's impleading application was filed in the context that it was only restricted to petitioners. Now that we have opened it up to everybody, so.
Please.
Yes.
And you as mismatch. But I am entitled for second counseling, there is no dispute. But despite that, all other doctors are continued after counseling. I have been given to that extent, your lordship, to protect my interest. But they are taking steps to review me. But that's my interest. Still,
Counseling is still in accordance with the act of business.
Before you start, what the competency of issuing executive order, over and above that, not related because your lordship is passing the judgment. With regard to the whether the government has got a power to issue executive order, when the field is. I have no objection. That is the reason I have not placed that.
Let's first I'll answer Sarthi's contentions. Page 77 may kindly be seen. Of his paper. Please, Manoj.
Yes.
Lords, he referred to this statement of objection reasons.
Yes.
Page 77, my lords, get it. This is statement of objection reasons, my lords, to amending Act 34 of 2017. There are more number of officers and staff who have completed 10 years of service in the same place. In order to transfer them in public interest, it is considered necessary to increase the 5% of transfer of medical officers and other staff to 15% by amending Rule 6 of Karnataka State Civil Services so and so Act 2011. So it 10 years, my lords, is prescribed minimum tenure, my lords, is only 3 years. Now kindly see section 6, my lords, for a moment, which is at page number 81. 81, subsection 1 proviso, my lords, after below zone A. provided that the total number of such transfers during the year shall not exceed 15% of the number of working strength in that cadre. So we have stated notes that the maximum limit is 15%. So below 15, I cannot go above 15%. Shall not. In that card. Earlier it was 5%. Notice what used to happen, it was when it was 5% statutorily also, on the basis of seniority, we used to come down. But by the time, my lords, we reach 5%, the persons, my lords, who had spent more than 10 years were not able to be moved out. So that was the intent of the rule. Now we have made it 15%. So the limit is 15%. It is a discretion, my lords, of the authority to what extent they can go. So therefore, to say that it is, because the proviso is very clear, it shall not exceed 15%. It is not that I should make 15% of transfers. So based on other exigencies, my lords, we decide on the percentage. So that may be left to the authorities, my lords, to determine. Now we have actually stated 5%. We are ready to go a bit more also. Till 7.5 or 10 based on the exigencies of service. Because if it was done in May and April and May, my lords, then, my lords, we would have gone till 15%. But since it is slightly after the code of conduct and now after the election, now we are again 2 months has been because of litigation also, my lords, we lost 2 months. So therefore, my lords, we wanted to restrict it to as much as possible, because again next month, April and May, we want to do this. We want to do. There will be another round of counseling. Please, my lords. Please. Act in the rules, please. Please, my lords. If it is, please. Please, my lords. Please, my lords. Please, please, please. I cannot change. I cannot change. I'm not doing that, my lords. In fact, he referred, my lords, to the statement of object and reasons to use the word 10 years. But in the act and the rules, my lords, the minimum tenure is only fixed at rule 6, which I read already, my lords, at page number 87. My lords may kindly say 87. The prescribed period is only at rule 6 itself. 87, my lords. Not section, my lords.
Whenever government hospital or government in the same area of or any other area of but what is zone A and what is zone B
Is also defined.
Is defined.
Is defined.
Is defined by the act.
Please, my lords.
And
Lords, I'm not, my lords. In fact, I have stated, my lords, there is how rule 6 and rule 10 operates. Rule 10, my lords, specifically is with regard to points. Where, my lords, I've stated their argument on the last day of hearing at rule 10, my lords, was that by virtue of, if my lords must kindly see page 89, in the middle of the page, zone A, B, C, and rural area is mentioned, and the points are also mentioned. So that will actually determine the seniority. Their argument also was on the previous day that by virtue of merging those zones into Bangalore urban district in respect of a certain geographical area, I will lose out this. That is not the intent, my lords, and we are making it clear that rule 10, my lords, we are not touching in so far as by virtue of clause 6 of the government order. In the government order, my lords, my learned friend has read the preamble where I've extracted section 6. Just because I've extracted section 6, rule specifically, the clause 6 refers to only rule 6. The Kannada word is rule niyama 6, and it is rule 6. It is not section 6. And only for the purpose of rule 6, my lords, that Bangalore urban district is taken into consideration, which is not contrary to the act, and the rules. And
your pretension is that you're not clubbing Bangalore urban area for the purpose of deciding the tenures.
If
Please,
they say
no,
so, I
for
have
the,
no objection.
for the, no, my lords, no, rule 10, no, my lords, 10 years, there is no 10 years, there is only 3 years. Minimum tenure is only 3 years under rule 6. Rule 6, minimum tenure is 6 years. 10 years, my lords, I don't know, my learned friend has read the statement of objections and reasons. That has nothing to do with that. For the purpose of rule 10, clause 6 of my government order will not apply.
Yes.
For the purpose of rules, it applies only for the purpose of rule 6.
Operation of priority list.
Lords, let us.
That's the only issue which my learned friend is. My learned friend is interpreting section 6, that of rule 6. Rule 6, 3 years minimum service, not the maximum service. If as I said earlier,
You will not be.
I will not be within the zone of consideration at all.
Be moved out, stating that you have completed the long-standing tenure.
No, that they have done so by executing the order. For a moment, if my learned, one minute, Lord.
Lords.
This my learned friend has clarified. I have read only with regard to the amendment. I request your lordship kindly take page 88. Rule 7. Because what we are dealing here is public interest transfers. 7.1 deals about 7.1A transfer under subsection 2 and 3 of section 4. Section 4 is this with rural service. We are not done. Compulsory rural service. And subsection 2 of section 5. Subsection 2 of section 5 deals with my learned friend representing mismatch. Next. Transfer of public interest under subsection 1 of 6. Rule 6 has no application to public interest because what we are doing counseling now is for the persons who are long standing in a particular place for more than 10 years. That is ruled as section.
My lords.
26.
Please, my lords, my learned friend, kindly note one thing, one clarification.
Proceed.
Long standing 10 years, my lords, there is nothing. 10 years, there is no question of 10 years. It is, if you have completed minimum tenure, you are entitled to be counseled. Counseling will be on the basis of seniority. If you have spent 15 years, you will be a top, you are entitled to go out. And by virtue of showing you in top of the list, consequently, your vacancy also will be shown. Because the word consequential has been interpreted in the government order in terms of this. Now, therefore, my lords, we are any which way announcing the priority list. We are any which way announcing the priority list. And even, my lords, with regard to the grievance that my learned friends are raising, with regard to the first round of counseling, all the persons who have taken the transfers, none of them are aggrieved, who are actually taking. Now, it is only with regard to their second round of counseling. And they're talking about that CEO, my lords, transfer order that was issued by the CEO. Plus, there was an authorization that was issued by the notification of the counseling was issued by the commissioner. The CEO, my lords, is an authority below the commissioner. The counseling was conducted by the commissioner, my lords. Only the ministerial act was delegated. I understand, my lords, on the last date of hearing also, my lord put that question to me with regard to, my lords. And, my lords, it's a curable defect. Now the commissioner, insofar as the persons who have actually taken and who are my lords, accepted their allotment in the first round of counseling, they are not before this court. So they should not have any grievance with their transfer order. My lords, I will get it issued with regard to the commissioner. It is only the second round of counseling that comes. So that is their grievance. I don't know why they want to scuttle the mismatch counseling that is already held. Because now their entire idea was to participate in the second round. Second round, again, you are in priority in terms of the priority list. So therefore, my lords, their entire idea is to stay put there.
That is not the reason. That is not, is
Long
factually
standing of
incorrect.
10 years does not arise.
Is
my lords.
factually incorrect.
Please, my lords. Please, my lords. Please, my lords. Please, my lords. My lords may say.
See with the counseling with regard of state of the act.
Please.
All the mismatch also, whatever is the number of the mismatch vacancies will be shown and the priority list. will be
Please.
shown.
Please, my lord. Please, my lord.
Here starting the counseling. I have a right to exercise my mutual transfer, which they are not providing me. That
No,
they
no.
have to provide.
My lords.
And
You-
also, they cannot
Because it is only one chance to me.
My lords.
whatever the stated, whatever the experience.
Please, my lords.
It's what is it?
No, my lords, insofar as request transfers is concerned, my lords, it is that once it has been amended to twice. That is a separate request transfers is a totally different altogether thing. It does not come within the counseling. It is request of two people, my lords, to go inter se. But still,
That will not come within the.
that is not
That
part
will
of.
be recorded for this reason because before starting it, they are not allowing me to take request.
With attention with regard to the activity that they have done. It's submitted that whatever is stated in the document will be given effect to the council requested only according to the act of the rules.
Yes.
It's submitted that the council will be held in accordance with the act. And that the government orders will be given effect only insofar as permissible by the act.
Please.
This further submitted that the counseling has been conducted by the appropriate authority as stated in the act.
Act.
And that the orders of transfer will also be issued only by the appropriate authority as provided in the act. It's further submitted that mutual transfers do not come within the ambit of the counseling, and that mutual transfers will also be
Only for bank
given
they are different.
effect in accordance with with what is provided under the Act. And that the statement in the government order, the effect that mutual transfers will not be able to.
Urban district.
Within the limits of Bangalore urban district will not take away their rights.
Let's,
Submissions are required.
no, mutual transfers for Bangalore Urban District is a separate government order, which is not part of this proceedings. It is not part of this, this government order does not talk about mutual transfers. It is a separate government order. It has nothing to do with. That is not the subject matter, Manoj. That is not the, if in the government order,
In this, the government order and the government orders and the counseling will not affect the rights of the citizens with regard to digital transfers as provided in the Act.
Good well,
And the
good well.
government orders. And the government made instruction.
Only for service.
Having entered the government. Without the opinion of the council. Has to be on. Fundings are there for that. To prepare the priority list and to conduct the councils in accordance with the Act. In case there is any provision in the government order which violates the provisions of the Act.
Please.
The counseling will be in accordance with the Act. We most of the state. The counseling as well as preparation of the priority list. The preparation of the priority list as well as and want in accordance with the Act. And the permission granted to the persons included in the responsibility to participate in the public interest counseling as well will be in accordance with the priority as provided in the Act.
Please,
let's,
please.
Yes.
the government order date is 3/8/24, my lords. It might come because there's the government order dated 3. And one submission, my lords. My contention with regard to mutual transfer, the first sentence, my lords had dictated, that had to be correct. My only submission was the government order relating to mutual transfers is different. Relate to government mutual transfers.
Please, ma'am.
Yes, what about submissions?
Let's, let's forcefully, we have not asked them to report any which way.
Please.
I've been asked to review
Which is the idea?
6 of.
Let's, we are making a submission that if any person were actually taken in the first round and wanted to participate in the second round in terms of our circular, is entitled to continue till the second round of council.
Stations.
Please.
Service has to be considered.
That is there as per the Act itself. The Act itself provides length of service.
Because otherwise this will once again a second mode.
Will not.
That is the assurance.
All here before us.
Obliged.
If as a matter of fact, it is conducted in violation of the Act of the rules, again you have to come to the.
Please.
Grateful.
Amendment. Amendment.
Six, yes, no.
All the yes, sir.
Amendment.
Even my
Completing.
pleading and transfers. I'm so grateful.
We list after 3 weeks.
3 weeks.
Email everything to please.
May be permitted to file objections to their obliged.
Let us know to it and not required. Yes.
Obliged.
That is the form for. And no further objections will be required. If it is substantially in accordance with the act.
If it is,
then individual cases-
because they cannot become only,
Please, please.
The substantially it is according to the act. Individual. You're sure that things are. Yes.
We go down.
They are taking, to give it today. No, I made submission. The officers are in court, they have heard.
Please be clear on this. Everything that is in this verse, is telling you that you will have, please take his word for it. Yes.
Go down.
Admission, seal number 2, Radhakrishna Holla.
Yes. Just a moment, dismissal is interfered with. Dismissal is interfered with by the labor. It is updated by the. By the university.
Yes.
Here on an interview. Labor court as well as the university. Have all in favor. The finding is that, yes. Yes. Can it be settled between, as to the quantum of that? Instead of
My lords,
going into all that?
My lords, if it is 75%, I am agreeable, my lords. Because they have retired almost 10 years back, my lords. Because the inquiry has been held not fair and proper, thereafter, I say very meager amount, my lords. At those times, the 300 rupees was the salary. 300 rupees was the salary, 50% of the back wage. Yes, my lord. Yes, yes, my lord. It's a viable industry.
Say that the quantum must be reduced. Basically an issue of discussion. And on the findings by the labor court. Unless there is such a patent legality in the findings of the labor court, scope will not. Respect to interfere. Learn civil judge will not interfere. So for an interference by an intra-court appeal, the requirement is much higher.
To put an end to the litigation, my lords. I am giving up to put an end to the litigation because it's 37 years, my lords.
So please, why don't you tell to settle it and then. Settle it at an amount instead of this percentage. Offer some amount which is accessible to them so they can be settled by it.
Better it's percentage, my lords, because amount means it may be, workers may say, feel that it's a too less or something like that. If it is percentage, that's a better, my lords. Yes, I am agreeable for 75% to put an end to the litigation, my lords. Yeah. Even, my lords, I am submitting even before consulting my clients. We are agreeable and I convince them for 75%, my lords.
Again, they can.
I,
Take it.
that's true, my lords. That's true.
And that, constitutes- And that an attempt can be to resolve the dispute amicably between the parties. This approach to report whether settlement is. Yes. Please work that out among yourself. The date you can agree among yourself that is the end of it. We just list it after date. If you can, that is the end of it. Otherwise, you have to hear it from it.
30th.
Before that, one day. Before that.
For them, they.
Has to be.
That's all right. We will meet and we will discuss and we will agree.
23rd,
Yes.
3 adjourned. 4, Badri Vishal. Notices. Five. Before B group. Number 6.
Great respect, my lord, our contention is that the amount deposited by them does not meet your lordship's. The whole calculation is being evaluated. And the whole thing is given by. I send them by email on what they are saying. They are saying, I will deposit all the interest. The order says. What is the award amount? I get the lordship to next. Oh, sure, you have about 50% of.
Whatever is the difference.
People for have also asked me to record it.
Yes, fair enough. Can we hear the matter? Will we be ready with the matter? When can we hear?
Your lordships have followed the trial court records in market.
This week after 2 weeks, a hearing on the main matter. It's a 37. The window is very narrow. Therefore, that is all we need to consider. Instead of having a discussion on the 50% because the other main matter itself. Immediately after the setup break, we can. 15 plus 16.
15 we have one matter. 16th also we have. 21st. 21st.
Not to be more than 22nd.
28th.
Yes.
28/10.
Okay.
Yes.
2:30.
Very good. Thank you.
By the time definitely they record the order.
That should have come back.
Yes. Please. Yes.
Seven. Kumar NJ.
Objection and being progress. The previous part.
Notices. Notice.
This
Notice.
is. This is. Yes. Take that, sir. Yes.
After service. 30th.
Yes.
8 urgent. 9. Pradeep Nayak.
What happened in the mediation, 9 and 10?
Today, not direct the problem to that. We can't deal with the. But the problem here is going to be filed.
It's an inconsequential. What happened was in the prayer, we have said set aside the prayer of the, set aside the order, and we've added consequently allow IA1. It's not of much consequence.
Demonstrate the very meticulously drafted appeal, my lord. If it has been excluded, it has been deliberately excluded. And in
I
fact,
think
my
if
lord,
he's
trademark
going to
is-
start reading my mind.
Please move.
As this is purely obstructionist behavior, my lords.
Not at all,
It's a consequential, inconsequential amendment I have
I
sought.
will demonstrate it, my
I
lord.
have said, I have,
How meticulously the appeal has been prepared.
I'm grateful
how
for
it has
the,
been deliberately executed.
I'm grateful for the compliments my friend is paying me, but that's all, because an objection was raised by him. I have said, set aside, obviously my IA,
Statement of objection.
either he can,
relying on that omission, I have not brought it to their attention.
Here. Here the idea was. After 13.
it's any early date. I have had the benefit of an interim order until it was vacated. I have a trademark, registered trademark, and I've been using it since 98,
30th,
earliest possible date,
30th. of this-
30th.
30th, my lord. 26.
Could it be
26, 25th, my lord, or
18th, 19th? The appeal itself will not take more than half an hour on each side.
25th, 25th.
Deeply obliged.
Please.
Because it's largely a question of law. All findings are in my favor. Question is whether
11th.
For the respondent.
This one.
For ejectment. Suit for ejectment.
Yes.
His only ground was that he is entitled to one more renewal.
13A, my lord, application.
In the previous suit filed by him, he admits that the tenancy expires by the end of February.
My lord.
He has filed a suit for injunction. In the suit for injunction, he himself admits tenancy expire by the end of February 23. Nothing remained in the suit. Therefore, the court is justified in passing the order. Even assuming that he is entitled to one more renewal, that will also end by
My lordship, the appellant, my lord, is a tenant, my lord, under the respondent. My lord, the appellant was inducted as a tenant, my lord, in respect of 141 shop in A scheduled property, my lord, in the year 1997. Then, my lord, the tenancy has been extended from time to time. Subsequently, my lord, another shop in A scheduled property also let out to the appellant. And my lord, subsequently, my lord, lease has been enhanced. Period has been enhanced, my lord, rent also, my lord, enhanced from time to time. And my lord, subsequently what happened, my lord, and another portion that is B scheduled property, my lord, that is B scheduled property was also, my lord, mortgaged to the respondent, my lord, for rupees 12 lakhs. And subsequently, my lord, he has repaid the 6 lakhs and tenancy continued. And my lord, subsequently, my lord, what happened on 1/4/2020, my lord, 3, my lord, there was an understanding between the appellant and the respondent, that, my lord, at that point of time, my lord, in the February 2023, rent was, my lord, for both the premises was 38,000 and hard per month, my lord. And, my lord, on that day, my lord, after that termination of tenancy, my lord, in the year 2023, there was a understanding between the parties that, my lord, the tenancy has to be enhanced for 10 years. My lord, with the rent, my lord, if the appellant is agreeable for paying the rent of 60,000. Under these circumstances, my lord, and 38,000 in the 60,000 rent was enhanced. For that, my lord, I'm permitted to produce, my lord, account extract, my lord, which is produced.
Good. I'll produce the plaint filed by, I will pass on the plaint filed by him. I'll pass on the plaint filed by him in the earlier suit.
The tenants. That. Till then, my lord, the today is last day for vacating, my lord. 30 kindly time is granted. Time may
By
be
2:30,
interim order action.
by 2:30 it can be heard. It will not take more than 10 minutes. He wanted some more time.
ಅಲ್ಲ
See,
ಅವರು
even he wanted some more time. Even agreeing that he is going to have some more time.
ನಮ್ಮ ಕ್ಲೈಂಟ್ 2 years ಇಂದ ನಾನು ಅಡ್ವೈಸ್ ಮಾಡಿ ದೇ ಆರ್ ಕಮ್ ಡೌನ್ ಫಾರ್ ಮಲಾಡ್ 1.5 year.
1 year ಹೇಳಿದ್ರೆ.
ಅಲ್ಲ ತಾವು ಇವ್ರು 1 year ಕೊಟ್ರೆ ಐ ವಿಲ್ ಅಡ್ವೈಸ್ ಮೈ ಕ್ಲೈಂಟ್.
ಒಂದ್ ನಿಮಿಷ.
ಅಲ್ಲ
No,
ನಾನು
1 minute, my lord.
ಹೌದು.
Even according to his own case, he says he is entitled to one more renewal. So renewal must be from 1st March 2024. It will come to the end by January 25. Another 5.5 months. 5.5 months is spent. So even if all the accepting his contention, he will be entitled to another 5.5 months time. No, that is the only contention advance.
1 year time may be granted, Malad, we will vacate without Malad fail. ಅಲ್ಲ
No, I said, see,
ನಾನು
even according to your own defense, in the,
If you can work out something, please do it.
no, I am ready for argument, my lord, today itself.
kindly
The reason is,
interim order may be
my
passed.
client is 73 years old. He want to settle in himself in life by putting up new construction. Whatever the savings he has got. he
No
want to-
document is produced Malad for
Necessary, you are not concerned with that.
no share.
No.
Not Malad, yes, a
No.
capacity and Malad, yes.
Therefore,
Kindly Malad.
even according to their own statement, what they say is they are entitled to one more renewal. That will come, even if one more renewal is
Not-
granted, that will come to the end of February 25. So 5.5 months he had already. Another 5.5 months he can have it to close the matter.
Kindly Malad, this is the reason Malad, is agree.
Your next renewal will also come to an end by February.
Yes,
Not in the next year. My understanding, Malad, tenancy has to be enhanced, Malad, another 10 years.
yes, you can say 100 years. What is that?
Contention. Kindly Malad,
There is no document.
if it's agreeable for 1 year, Malad, we will vacate on 1 year from today, Malad. There is no. Definitely, Malad, definitely we will.
No, 1 year time is too long because he's, even according to this, he is entitled to another 5.5 months time.
We list it next Tuesday. If you come to an agreement.
Kindly grant the interim order.
I will not execute it. Till next date of hearing, I will not execute it. I have not filed the execution. And the
But
execution will not
kindly
be
Malad,
filed
the
next
interim
date.
order may be passed.
No, not like that. I will not file the execution till next date of,
It's next Tuesday.
Great,
Please attend second.
great.
in these ejectment suits, nothing is there.
Without inquiry, Malad, without inquiry,
What
without
is
whether
that,
the lease has been terminated validly or not. Summary judgment passed. 12.
I appear for the appellant, my lords. My lords, the appeal is under section 37 of the Arbitration Act, my lords. My lords, yes, my lords. Yes, my lords, 38. Yes, my lords. My lords, the only point that is involved in the present case is, my lords, the land is converted for industrial purpose. But the second respondent wrongfully came to the conclusion that it is converted for commercial purpose. May I refer to the relevant point in the order, my lords? My lords.
Then the property was converted from residential to industrial purpose in the year 2002.
Yes, ma'am.
The writing that is secondary to the court. When such cases is implemented the following special labels probably done to the nature of the land and the work occupation. When the operator is taking the situation nature of the land, then has to pay compensation for considering the land is commercially converted. Such clauses are very important. Yes.
My
What
lords.
would be the difference if it is?
My lords, it would go by 40%, my lords, up by 40%. Now the total compensation that is determined is 38 lakhs. it would go up by 40%. After the valuation, additional 40%. We are seeking for the stay of the annexure C, my lords. My lords, annexure C. My lords, it would go up by public money is involved, my lords. Annexure C, my lords, subject to deposit, my lords. My lords, 6 weeks, my lords. 6 weeks, my lords.
Please, my lord, I pray for a short pass over, my lord.
For the respondent. Give it. Please.
Please, my lord, I pray for a short pass over, my lord.
$17,900. 14. They thought for time.
For R1 to 4, my lords. For R1 to 4.
Urgent.
Please.
Preliminary hearing, so number 16. BB Patil.
With your lordship's kind leave, my lords, for better understanding, I seek my lords to have the map which is at page number 728 of the appeal memo. Delay, my lords, delay petition. My lords, this was during the COVID period. That is why the Supreme Court. So that, my lords, it's not been condoned yet.
No, we are appealing. No, condone.
Both the appeals. Yes.
My lords, may please have the map at page number 728 of the second volume of my appeal, my lords. My appeal is appeal number 28 of 2022. My lords could please have page number 728. Second volume.
Yes.
My lords, if my lords were to please permit me, survey number 56/3, which is highlighted as a box, is the lands that belong to the petitioner. 656/3. Incidentally, my lords, the entire land, along with land onto that side and this side, was all notified under the Karnataka Industrial Area Development Act. 14/6/2013 is the preliminary notification. And the final notification is 31/2015. This is not a my lords, 31/2015 is the final notification. Now, my lords, incidentally, at that point in time, what was proposed was only a 60-meter road. During the, my lords, the petitioner, the appellant, as in the land loser, calls in question these the acquisition proceedings before this court in the year 2015. During the pendency of these proceedings, in the year 2018, National Highway proposes additional acquisition of 2 small patches of land, thereby increasing the width of the road from 60 meters to a further length, my lords. 15 meters additionally on both the sides. If my lords were to see the diagram, we have given that smaller portion on both the sides of 15 meters.
Is there acquisition was with respect to the large area, 196?
Entire area
Yeah, on the other side of the.
was also covered under my acquisition.
This commercial area.
Yes, everything was covered. Everything was covered. In fact, my lords, when National Highway notifies it as late as 2018, my name, that is Karnataka Industrial Area Development Board, is reflected in the revenue records and their notification as well. So my case, my lords, before the learned single judge was that these lands have already vested in the state by a vesting clause under the Karnataka Industrial Area Development Act, 28 subclause 5. Thereby, they stand free of all encumbrances in me, and any further notification or any subsequent acquisition which is made should inure to my benefit because I am the owner of the lands as such. Now, this was my proposition. Now, other than this, my lords, there is another one facet which was raised by the land loser. There is a small portion of this land, my lords, onto this side of the road, onto the lower side of the road, if my lords could have. It is not depicted. The claim of the petitioner in my acquisition proceedings under the Industrial Act was that he had already established an industry for 2 acres. And he wanted, my lords, that land to be deleted. When under 28(3) proceedings, where, my lords, his objections are heard, there is an observation specifically made in that order as against his objection that there is an industry, that this is a defunct industry and a non-functional industry, and that is why we are overruling your objection, and that was overruled. Even, my lords, it is undisputed a fact that as early as the passing of an order under 28(3), which is much before 2015, there was officially a noting in the order that it is a non-functional industry as such. My lords, that land has to be, no, my lords, what learned single judge says is that in page number 25, my lords, he's given us 5 pointers. After giving the facts, I'll come to that. Now, my lords, my case on the first leg is, my lords, that subsequent notification, he won't inure to his benefit. I'm already the owner. So whatever the compensation under the original notification is entitled to, let him take. Whereas the learned single judge, my lords, was pleased to hold that the NHAI compensation, which is as late as taking the preliminary notification in 2019, is entitled.
Land to be NHAI.
I had no, please, the 60-meter road I had given free of cost, not the other portion. That is why NHAI only conveniently notified only the other portion. And that portion, my lord, is the compensation worked out to about 2 crore rupees, and they were pleased to deposit it before the court because
Which has been paid.
by an,
Paid.
that is part of the interim order, my lords. No, my lords, it is released to him by the learned single judge's order.
Yes.
Now, what happened, my lords, is during the pendency of the petition, there was some disturbance being created to National Highway. So National Highway promptly came before this court and said, this is my acquisition. No, no, we are willing to play, my lords. But they're willing to play in the sense, my lords, they deposited it before this court.
And subsequently.
And subsequently as passing of this order, which is under challenge or impugned herein, it was released. So that would be, the release would be subject to the appeal proceedings before this court, is my respectful submission. Even otherwise, my lords. Is he entitled to is a question this honorable court has to decide. Because the acquisition as under my statute is already complete. Yes, my lords, there was a stay. There was a stay. And that is why this whole, they coming before the court, they being implemented and they not being permitted to work, that all, and that interim order is merged into the final order as such. Now, this apart, my lords, the learned single judge, my lords, may please permit me to read the impugned order operative portion at page number 25 of the first volume.
Page number 25, my lords, first one. Insofar as 2 acres of converted land, this is the land which he alleges that he has set up an industry. The petitioner in survey number 56 concerned, the KIDB shall make endeavor to integrate the same into the proposed industrial area. That is, we were directed to integrate his industry, and even we took a contention, my lords, that there is a park here marked there in my map. If my lords were to see the map once again, there was a park. According to my planning, now I have to redo the entire map was also one of the contentions I raised. My layout formation itself will get disturbed as my submission before the learned single judge. And it was not intentionally, my lords, already my map was there in place when the contention was being taken up and it was heard. The same proposed to the industrial area, if such integration is fruitful, permissible development charges to be collected from the petitioner. So, my lords, first of the release that was given to the land loser was, if his lands could be integrated, we recognize it as an industry, and only the differential development charges, because he won't claim compensation because he'll be entitled to the land as. Now, next one, my lords. If the said 2 acres of the converted land cannot be integrated into the proposed industrial area, the petitioner shall be allotted alternative developed area in the same layout to the same extent. In such circumstances, the petitioner shall be entitled to claim compensation in respect of the buildings and depreciated value of the machinery and other equipment. Finally, my lords, the petitioner is entitled for compensation at the hands of fifth respondent NHAI to an extent of 2090 square meters. That is the 2 small patches which are around the top and bottom of the road. Therefore, registry is directed to release compensation which was deposited to the tune of 1,99 lakhs deposited by fifth respondent along with accrued interest to the petitioner on proper identification. Now, next, my lords, the petitioner is entitled for compensation determined by SLAO in respect of the remaining portion of the land belonging to the petitioner other than 2 acres of converted land mentioned here. Now, my lords, inasmuch as the fourth relief is concerned, we do not have any objection. Our relief, our contention or the appeal is restricted to only to the first 3 of the pointers. Based on the ground, my lords, that firstly, the land itself which he is claiming to be converted and using to be an industry, during the 28-3 proceedings, there has been a finding, a categorically factual finding, unlike in a writ proceedings, my lords. A factual finding when a spot survey was done that this is a defunct industry. Once it is a defunct industry, my lords, maybe he might be entitled to the building, the other malkias as such. But that should not inure to his benefit as a converted land or for that matter as a functional industry. If it was a functional industry, invariably we would have integrated it. Now the second point, my lords, is even assuming he is entitled to that land and an exchange rate, the policy of the KIDB, my lords, or the government of Karnataka under KID Act is that you could seek compensation in 2 manners. It's actually defined under section 29. I won't bother, my lord. Section 29 of the KID Act says it deals with compensation. You could either enter into consent or you will have to draw up a general award under 29(3) and deposit it in civil court or give him. In case of consent, he cannot go for further enhancement. Whereas in case of a general award, he can go in a manner known to law. This is the statutory. Based on this statutory formula, the KIDB has evolved a policy called a land-to-land exchange. In case of land-to-land exchange, what the government has done is issued a notification itself. For every acre, if there is someone who wants land instead of compensation and wants to be integrated into it, for every 1 acre required, 10,000 odd developed industrial land, which is 10,000 square feet, which would be, my lords, with all amenities of change in land use, roads, electricity, etc., all paraphernalia comes within that he is entitled to. If not, my lords, he has to pay. Actually, this is not available, my lords, in terms of statutory provision or any circular as such. But as a matter of practice, if someone says, I want to develop an industry myself, then he is made to pay the differential cost of development charges. How the development charge is calculated is that they take the entire layout, my lords, acquisition cost, development cost, and divide it on a pro rata basis on every acre. And they determine, other than the land cost, only the development cost, and say you pay this much. And you have no right to compensation as such. Now, here is a case, my lords, my appeal rests only on these 2 grounds, my lords. One is once the notification, as regards the compensation, once it stands free of encumbrance in me, there cannot be a divesting. Any subsequent action, I will be the owner. And to add icing to the cake here, my lords, my KIDB was reflected, it is noted. It was raised as a contention also before the learned single judge, that my name was part of the notification of NHAI. It is not a disputed fact.
What was the entire area belonging to?
It was about 6 acres, my lords, that entire, that 56/3 in the map which I have connoted. Yes, my lords, no disputes about. Not only that, even the area above that onto that side, if my lords were to have the map once again. In fact, it's a very interesting situation where his land, my lords, falls both the sides of the road, onto that side and this side. Narrow strip on top, a huge chunk on the bottom, in between the road passes through. We had notified everything as per our original preliminary notification and final notification. Lord, because I have to pay him compensation. I have noted, I have remaining, I have to pay him. That is why 4, I cannot have any contention as such. I cannot be unreasonable to take his land in violation of a statutory provision as such. It mandates that under 21, I have to give him compensation. I am giving him 300 a, not 21%, 300 a. Article 300 a. So I'm 4, I have no objection. I have objection only with 1, which would be asking me to integrate it, more so when it is a park in my layout. Now, my lords, if I integrate him also, I have to show that park somewhere else, because as per the building bylaw or layout regulations under the Town and Country Planning Act, a certain percentage has to earmark for park, for green space, parking area, etc., etc. So,
There is no question.
1 and 2 itself. And my notification, my lords, is a restricted ground. Or what are the accepted grounds in a writ jurisdiction on which a notification could be called in question? 1, my lords, no notice is issued. 2, non-application of mine. My lords, he has participated in the proceedings. He has made a contention that it is an industry I have set up. He says that it is functional. I give a finding in the 28(3) proceedings that it is not functional, it is defunct. And I overrule his objection and then notify the whole thing for acquisition. And that has vested free of all encumbrances instead. In as much as compensation is considered, he is entitled. Please, lords.
My lord, my
I will-
submission is, it is a running industry. There is absolutely no report to show that it is closed. And only the land acquisition officer has given us just a note. It has been relied upon. It is a running industry.
My lords, para 5. Learned senior counsel Sri D.N. Ranjit Reddy appearing for the petitioner would submit that it is evident from the material on record that the SLO has failed to consider the objection filed by the petitioner. It is pointed out from the file notings of the SLO that he has rejected the objections by merely stating that he visited the spot and found that it was not a running industry. He visited the spot is undisputed. And he found it to be not running. Now, could it be replaced by a factual finding in a writ jurisdiction is a question that begs for asking, but I will further continue. Substantial material has been placed before this court to support the contention of the petitioner that the petitioner established an industry in 2 acres of converted land. Established, I don't dispute, my lords. Non-functional is my case. Yes. Nothing. It is actually a defunct one. There is no dispute about it. The learned senior counsel would also draw the attention.
It is a disputed. You can't say it is undisputed.
No, my lords, they should have shown some kind of documentation as on this day.
I have got electricity bills also on.
And more so. And I'll agree. My lords, more so, could that finding be given in a writ jurisdiction is my submission before this court. Especially when the acquisition proceedings have been called in question. Could a factual finding could be, an endeavor could be made. It could at least be remanded back, at best. The learned senior counsel would also draw the attention of the court to a circular dated 16(3) issued by the Government Industries of Karnataka, providing guidelines to KIDB in matter of acquisition of agricultural lands. It is submitted that it is clear from the circular that if there is an existing industry, Even if it is a sick, the same was not to be acquired before the authority. It is not to be acquired, my lords, it may, quashment may be there, that is, I'm not disputing it.
Yes.
Next, my lords, insofar as the second acquisition is concerned, the learned senior counsel seeks to place reliance on one judgment. Per contra, learned senior counsel Ashok Karnali appearing for KIDB would submit that the circular so and so relied upon by the petitioner does not place a complete bar on acquisition of an existing sick industry. My lords, because this circular is a circular issued for an internal guidelines inter se for effective acquisition. What happened, my lords? I'll give the factual situation. Vast extents were notified. And then, my lords, about 20% of them were proposed to be denotified. Now that created a lot of legal hassles. That is why what the government did was, as an internal regulation, we are telling you people that you should follow these guidelines. And those guidelines also, my lords, time and again say, if they do not affect the contiguity, they are in Kannada, my lords. I will put it in local language to say, Ayu kattige dakke agadante, which means without affecting the contiguity of it. You could delete these lands if there is a temple, if there is a school, if it is within 100 meters of, or it is an agriculture crop yielding land which grows 2 yields a year. These are all, my lords, subject to a certain condition that it don't affect the contiguity. Now, if it falls bang in the center of an industrial area and they take to, if I keep deleting it based on that circular, which actually doesn't give them a right as my submission, assuming it does also, it will only give me potholes in the entire industrial area, making it an impossibility for me to acquire the entire thing.
Yes.
So, my lords, next one, existing industry. My lords, I'll read out the further order, my lords. It is pointed out from the said circular that as far as possible, an existing industry should not be a part of acquisition, provided it does not affect the contiguity or compactness of the establishment of a new industrial area. The learned senior counsel submits while pointing out to the scheme of the proposed industrial area that the land in question falls within the proposed industrial land, therefore the said lands could not be left out of acquisition. Even otherwise, it is pointed out from the documents submitted by the petitioners that the bill and invoices raised by the petitioners only till the year 2002, which would show that the SLA was right in his opinion that the industry established by the petitioner was no more a running industry. As regards the decision cited by the learned senior counsel for the petitioner, it is contended that the acquisition notification issued at the behest of NHAI cannot be considered as a successive acquisition. That is also true. Because successive notification, the benefit inures to the land loser if it is the same proceedings. But if it is a totally different notification issued by another state instrumentality, like here it is the industrial body and the NHAI, they are not considered as successive is what is given. The notification issued by establishment of an industrial area is of the year 2013 and 14. Though the final notification comes in 15 months, the preliminary is in 13. While the notification issued by fifth respondent, which is NHAI, is of the year 18 and 19. For the purpose of formation of the national highway. Moreover, it is submitted that some part of the lands notified the KIDB, not only for the petitioner, but for also neighboring lands are acquired for the formation of the national highway. My lords, if my lords were to see the map, that highway continues through and through across the entire stretch. So if this finding is given, it would have a cascading effect for all the lands on both the sides, is our submission. The KIDB has taken a decision to hand over the portion of the lands which are required for the formation of the national highway free of cost, the center portion. Only the center portion of 60 meters. That is why national highway was, if I was giving it free of cost to national highway would not have to again notify it. And my lords, that is why the learned single judge rightly, unfortunately for us, has not given the compensation for the entire land. Because my compensation for the main portion of the road and the rest of the lands has to be determined in a manner known to law, which is yet to happen. Learned counsel Shilpa Shah, appearing for the fifth respondent, submits that since the lands were required urgently for the formation of the national highway and the formation of the highway in the rest of the portions were also complete, interlocutory applications were filed before this court seeking permission to go ahead with the formation of the highway on the lands in question. By an interim order dated so-and-so, respondent 5 was directed to determine the compensation and deposit the same before this court. Accordingly, compensation has been determined and deposited before this court. The fifth respondent was permitted to go ahead with the formation of the land, the formation of the highway in the said lands. Third learned counsel so-and-so. Insofar as 2 acres of converted land where the petitioner is said to have established an industry, it is required to be noticed that SLO has stated in the notings in consideration of objection raised by the petitioner that he has inspected the premises and found that although there existed an industry building, however, there is no industrial activity and therefore SLO comes to conclusion that there is no running industry. The documents submitted at the hands of the petitioner, such as invoices pertain to year 2002. The writ petition is filed in 2015. And therefore, the respondents are justified in the contention that the industry established by the petition was not in operation. The SLA was also considered the objections raised at the hands of the petitioner and stated in the consideration of objections under section 28(3) of the KID Act that the land in question falls within the proposed industrial area, and in order to maintain contiguity and compactness, this is as per his own circular and government guidelines of the industrial area, the land in question cannot be left out of acquisition. If left unacquired, the land in the question would form an island within the industrial area. This is observed in his order only, my lords, and a judicial noting of that has been taken by the learned single judge. Nevertheless, efforts will have to be made while forming the industrial area to integrate the industry established by the petitioner to an extent of 2 acres, and the petitioner shall be entitled to the same extent of developed land within the industrial area. Insofar as the acquisition notification issued by fifth respondent, that is 1, my lords, and 2, the compensation. He has already taken the compensation, which is an exorbitant amount, as against the rest of the compensation. These are the only 2 broad grounds that have to be considered.
Yes, will it take some time?
No, my lord, I will take half an hour. No, my lord, I have to, because this notification was issued in 2015. And so far, they have not taken possession. No compensation is paid. Whether the land west, the word used in 28(5) is west. Vesting is the ownership or not is the question to be decided. Because, my lord, the further provisions has to be read in the matter. And, my lord, simply because it's west and 28(5). And, my lord, my submission is, thereafter, my lord, they have to survey the land. They have to pay the compensation. After paying compensation, they can take possession of the land. And the notification is issued by the state government, not KIDB. It vests with the government. Yes, yes, I will just point out, my lord, your.
Yes.
Also, Lord, I am in some matter, parted.
Any other day, any other day, which one?
Tomorrow, my lord, because it is fresh in your lordship's mind, so that then I can go ahead with the matter. No, my lord, convenient to the court, I am not. Convenient any day.
I'm also there, because it's actually me who is running the industry up here.
Oh.
My
No.
And my lords,
There is one original suit is also pending. So their
No.
locus is also in question.
my lords, more so.
Original suit, if original suit somebody has filed after 100 years of the cause of action.
Lords, even otherwise, there was
100
an
years.
extreme order restraining me from taking any action. I couldn't have taken possession or made award as such. Interim order specified.
Status quo. Yes, possession.
My lords, I'll say that.
Anyway, my lord, your lordships are adjourning the matter. Any convenient date may be given.
Only preposition of law, I would say, my lords. Inasmuch as calculating computation of period for award also, status quo should be read as not any further proceedings is a settled position of law. Supreme Court as late as 1990s has said that if you are taking the period of 11A, that is period between that and that, any further action is barred.
It is not in respect of this land. It is 195 acres. What is that here? They don't have money in their government, and they say that they want to acquire 195 acres. As if, a status quo is passed to the whole of the land.
I didn't get my lords.
Absolutely to anybody.
No, others we have paid. They are not before the court. This is a sweeping statement being made. We have paid everyone, only this gentleman, my lords, because there was an interim order. If not, we'll pay him right away. That is not a problem.
Pardon?
Please. Please.
Hmm.
Please.
Tuesday.
Please.
Okay, okay.
Please, deeply obliged. Deeply obliged.
17 urgent, 18 Ravi HK.
Records are called for and records are produced. Have you seen the records? Records.
They have given a copy of, yeah.
Yes, this is an exchange between 13, 18.
The order.
That was the only question. Next week. Next week, any date, Lord, 17th, 18th.
17.
Obliged.
19 Anil Kumar.
For respond.
Point is no son. Correct. Correct, correct. Because we had mentioned that the grant order copy doesn't have a signature and it's only written copy, to only with regard to the verification. Please correct me. That's the point.
My submission would be Annexure A is the order which was granted in their favor. The very same order reads the earlier grant. If they are not aggrieved by that order over which they have derived title or in respect of.
Correct. That's the short point, Manoj.
Yes, my lord. Madam.
This is the only question. The order itself is the order itself.
No. Annayappa himself relinquishes the right in favor of the petitioner, confirming the earlier grant, my lord.
Please, I'll get the records. Yes, make available para 3 and 4. It's only given up the right. Yes. Whether it's relinquishment.
Please, please. A date may be fixed for that. Great.
And also the connected records with regard to alleged grant in favor of appellants also, they are claiming a subsequent.
grant. 30th. 20 A.B. Gangadhar.
Yes, records were called for and I had also sought for time on 2 occasions. But records are not presently available to us. For the reason that digitization of records are taking place and they could not lay hands on these records immediately. But they got the original, the Tahsildar is present before the court, sir. They got the original register, wherein in writ petition 808 of 1984, records had come to this honorable court at one point of time. And thereafter the records, they'll have to trace whether it is back in the office. Because digitization is taking place, all the records. understand. 84, the claim is only that 1 hour and 24 meters in survey number 1.
That's all, because the rest of the lands have been already ordered to be. Please, that's right.
After vacation.
No, no problem, but only thing is, my difficulty is possibility of I being dispossessed by the authorities of the government. No, even till today, we continue to be in possession.
It's already been sold to some.
No, that's not. In fact, application was filed before the Special Deputy Commissioner.
Direction. Submit a report as to who is cultivating the land as of now, as on 10/6/2024, there's a direction. I shall inform the Tahsildar to get a report also.
Because cultivating at the relevant time.
Yes, that is on 1/7/1970 would be the relevant date.
The order of this honorable court secure the record and also the Tahsildar to submit a report as to who is cultivating the land now. The word now.
As on that date, whether the Tahsildar would be in a position to, whether the Tahsildar would. Let there be an order of the court so that. Please.
Report regarding cultivation also to be submitted as per 10/6/2000.
All those.
That does not
All those exercises were required to be done when the matter was pending before the Special Deputy Commissioner, not at this stage in 2024.
The appellant's counsel would be.
Anyway, we should, we will.
Appellant's counsel would be well aware why this order was passed, my lord. The government advocates would be changing, but on 10/6/2024, there is a specific order.
Yes.
21.
21.
Alala.
Ah,
Next serial. 21. 21/10. 21.
I mean, connected matter. Yes.
The reason for,
The learned single judge, my lord. Yes, my lord.
Yes, Lakshmi, in my expedition, 872, there is a 62 days delay. Yes.
Yes.
I'm in the another connected matter.
Connected matter process is not ready.
Yes, 5/31/22. I'm appearing for the appellant.
Prior to be carried.
He's compliant with the observation, he insisted on a near date.
Yes,
So now the delay is being controlled.
please, ma'am, please, ma'am, please. Right. Please.
Connected matter, they have to take out the process.
There is no question of process, my lord. A fifth respondent service was held sufficient in the writ petition. They were not contested. The person who is represented, my lord, is now, the contesting respondent is already on record. Somebody has filed the wakalat.
Yes.
Twenty-two, 23 adjourned, 24. Sandesh Kumar.
Yes.
It's not, regular promotion.
Oh, sorry. Not 9 minutes.
Sandesh Kumar and
In this, this is Mana. Yes, yes. Yes.
No, no. Your rule 38 and rule 32 was a 20.
Yes.
You saw.
Just can you pause over that?
Yes. Happens on the.
Yes.
Because the rule and fines, if you what was the ratio? When would you be entitled going by the ratio? No details were given. Enter a year, representation is not your application. If the writing is correct on facts, I think you will. Yes.
Hearing on a 25, adjourn 26, Sunita Srinivas. I appear for the 32 days.
I filed an counter making objections with respect to condemnation of delay, you lot me. Because they have filed a very casual reason.
I've got a better affidavit if I may be permitted.
It's not been served on us yet.
I'm just serving. I'll file it in the registry. Fine.
Very well.
But what they served came to us only last night. We had a government company.
Very well.
Yes. 27,
Like.
Srinivas Reddy, Whitefield Shelters.
Number 27, my lord. My lord, in this case, my lord, we filed NOC Wakalat, my lord, but our name is not shown in the cause list, my lord.
It's an date was given on this specific date.
But
The
we
last
have
date
received,
had the same submission. Earlier,
No, no, no.
advocate filed a retirement memo. On that day, they came and appeared and said that we are filing today, the no objection.
No,
On
no,
that
no. They have-
submission, it was.
that day they have
the
filed
date
a-
was fixed today. My lord, kindly see the main.
list is tomorrow, man.
Records have come, it may be heard and disposed of. It's more than 15 years, my lord, the case is.
So many matters.
Not today, my lord. A date may be fixed for hearing itself. That's what. Anyhow,
Any date.
records have come, my lord.
V. Vishwanath Shetty, my lord. V. Vishwanath Shetty.
On 25th, 24th or 25th, my lord. My lord, kindly see 2007 is the suit, my lord. It's a commercial land. I am not able to develop. It's more than almost.
And
20
they have
years it's
undertaken to
coming.
not to alienate the property till disposal of the appeal.
No, that undertaking was also given on
Much obliged.
30th.
28, Devrajji.
List ಅಲ್ಲಿ preliminary, yeah? On preliminary itself, no, my lord. Yeah, I'm ready. Yes,
sir.
on that understanding, yeah.
The difficulty is only with regard to time. We have code difficulty. The difficulty is that.
It's a time.
Time.
Much obliged.
28, Devrajji. Notice.
Yes, 16 days if I can take. Notice.
29, Chandrakant Targole.
Appearing for the appellant, my lord. Yes, ma'am.
Last one matter.
Please.
Just before my learned friend starts, my lords. In the other matter, on the last date, my lords, I sought your lordship's permission to file on this. That is the court copy. This-
Code copy.
That, my lords, can we take this on record? Is there, my lords, on the dissenting arbitrators, my lords, findings, there's a short note.
Yes.
Please, what fine? Need a short note, my lords. My
Yes, on that. That is on the, in the other matter, my lords, on the main.
This is what.
This is not on the cost, on his appeal. Not. You have given them, okay?
Please. Para 3 of the note. The question as to whether there is a power to modify has been referred to a larger bench of the honorable. But my submission is that when a reference is made in another judgment of the honorable Supreme Court says the earliest law must be followed and not the latest law. The reason, lords, as I see it, appears to be that same bench strength cannot overrule if, therefore, the former will be the prevailing law till Supreme Court finally adjudicates. The first judgment on this point is McDermott. That is of 2006, which says there is no power to modify an award. Therefore, lords, in short, my respective submission will be that that's the position that will prevail until and unless the reference is decided. And consequently, all decisions of various honorable high courts would simply be per inferior. In that light, lords, may I respectfully request your lordship to kindly see the reference order first at page 115 of my compilation. Page 115 is a short reference order. We are of the considered view that the following questions need to be referred to a larger bench for answers. Whether powers of the court under 34 and 57 will include the power to modify an arbitral award. If the power to modify the award is available, whether such power can be exercised only where the award is settled and a part thereof can be modified. Whether power to set aside an award under 34 being a larger power will include the power to modify an arbitral award, if so, to what extent. Reiteration. Whether the power to modify an award can be read into the power to set aside under 34. Whether the judgment of this court in Project Director NHI versus Hakim followed in Larsen and Pinto and SV Samudra laid out the correct law, as other benches of 2 judges in Vedanta, Oriental and MP Power and 3 judges in Udraja, Tata Hydroelectric Power, Shaktinath of this court have either modified or accepted the modification of the awards under consideration. These are the 5 questions. Now, if the lordship will please see my notes, the next judgment at page 118. This is on the principle of which is to be followed in such circumstances. May I request my lords to kindly come to para 35 at page 136. The only relevant portion will be the last 6 lines. It says, bench full stop in any case. First portion is that courts must decide and need not wait. The relevant portion is from in any case, when faced with conflicting judgments by benches of equal strength of this court, It is the earlier one which is to be followed by the High Courts as held by a 5-judge bench in National Insurance Company versus so and so. The High Courts will of course do so with careful regard to the facts and circumstances of each case. Therefore, the former is to be followed. In the reference order, there is indeed a reference to certain 3-judge bench decisions of the Honorable Supreme Court where a modification has been upheld, whereas the law that is laid down is all 2 judges. I must say that. But my respectful submission is that in none of those judgments, there is a statement of the law. It is only what the court does. And what's in NHI versus Hakim, the Honorable Supreme Court says, most of these judgments where the Supreme Court is actually either modifying or upholding a modified award, they say they are all exercise of power under 142 and therefore they are not precedent. Your Lordship, in this slide, kindly see first McDermott to show that the earliest law on this point, the first interpretation of the Supreme Court is in 2006 under the 96 Act, where the Supreme Court says that power is just not there under 34. The relevant para, your Lordship will please find at 52 at page 28. Act makes provision for the supervisory role of the courts for the review of the award only to ensure fairness. Intervention of the court is envisaged in few circumstances only, like in case of fraud or bias by the arbitrators, violation of antitrust, etc. The court cannot correct errors of arbitrators. It can only quash the award, leaving the parties free to begin arbitration again if it is desired. So the scheme of the provision aims at keeping the supervisory role of the court at a minimum level, and this can be justified as parties to the agreement make a conscious decision to exclude the court's jurisdiction by opting for arbitration, as they prefer the expediency and finality of the fight. The first, where they say the only remedy is award is to be quashed, arbitration begins afresh. Although it could in certain circumstances may not appear to be just, the court says that is the way it is because parties have voluntarily chosen arbitration, the mechanism. This is the first. Then your Lordship may kindly come to page 59, NHI versus Hakim. It is in this judgment that the Supreme Court says most other decisions are under 142. Therefore, they are not good law. McDermott is good law. In this, your Lordship may please come to para 31 at page 81. Thus, there can be no doubt that given the law laid down by this court, 34 of the Act cannot be held to include within it a power to modify an award. The sheet anchor of the argument of the respondents is the judgment of the learned single judge in Gayatri also. Thereafter, it may not be relevant. But if I may read this, the matter arose out of a claim for damages by an employee on account of harassment at workplace. Learned single judge referred to the power to modify or correct award under 15 of the 1940 Act. Thereafter, a number of judgments of this court were referred to, in which awards were modified by this court, presumably under the power of this court under 142 of the Constitution. In para 34, the learned single judge referred to para 52 in McDermott and then concluded that since the observations made in the said para were not given in answer to a pointed question as to whether the court had power under 34 to modify or vary an award, this judgment cannot be said to have settled the answer to the question raised finally. Then the Lords, from para 32 onwards, various judgments of the Supreme Court are dealt with. Para 32, last line says 142. Para 33, last line says 142. Para 34, last 3 lines may kindly be seen. Found favor with this court. In any case, a modification of an award upheld on facts without any discussion on the law does not carry the matter very much further. Para 35, in the middle of the page, 142. Then, my lords, in this background, the Honorable Supreme Court in para 40 says they are all under 142. Each of these judgments in para 40. Karnataka also referred to other judgments to buttress the very same submission, namely so and so. Each of these judgments also does not carry the matter further in that orders that are passed into 142 do not constitute the ratio decided by a judgment. Admittedly, there was no discussion on whether as a matter of law, a power to vary an award would be found in 34 of the Act. Then 48, 43 may kindly be seen notes. The Honorable Supreme Court also refers to law in various other countries and says this is the position of law there in para 43. A look at the acts of England, United States, Canada, Australia, Singapore also lead to the same conclusion. The rest may not be. In each of those legislative measures, there are express provisions which permit the varying of an award, unlike 34. Then in para so and so, learned single chance. After having held all these plots, the Honorable Supreme Court in para 48 at page 88 says, this is a Lakshman Rekha that a 34 court cannot cross. That's the language of Lakshman Rekha. 48. Quite obviously, one were to include the power to modify an award in 34. One would be crossing the Lakshman Rekha and doing what, according to the justice of the case, ought to be done. In interpreting a statutory provision, a judge must put himself in the shoes of the Parliament and then ask whether Parliament intended the result. Parliament very clearly intended that no power of modification of an award exists in 34. It is only for Parliament to amend the aforesaid provision in the light of the experience of the courts in the working of the Act and bring it in line with legislation worldwide. Then your Lordship may kindly see, my lords, page 93, 2024 part 3 ACC, the same law is rewritten. Page 93. 2024 part 3 ACC. Para 17 may kindly be seen at page 103. Para 17. It would be useful to examine the exposition of this court of the scope to interfere with awards on 34 and 27. The judgment on the order of the learned civil judge was dated so and so. The position as to whether an award can be modified in the proceedings initiated under 34 bar 37 is no longer res integra. While noting the provisions more specifically 34.4, the decisions rendered by this court, including the principles of international law, enunciated in several decisions recorded in the treaties Redfern and Hunter, this court in NHI versus Hakim categorically held that any court under 34 would have no jurisdiction to modify the arbitral award, which at best, given the same to be in conflict with the grounds specified under 34, would be wholly unsustainable in law. The court categorically observed that any attempt to modify an award under 34 would amount to crossing the line. So this is consistently followed in all recent judgments of the Honorable Supreme Court. My second submission would be that in this case, my respectful submission is this question of law. My submission would be that it need not even be gone into, because on facts under 34.5 there was an agreement between the parties. My submission would be not that if on merits, 31 years, if on merits, if this honorable court were to be convinced that there is a plausible case that the award can be sustained, then this question also need not be gone into courts, because it will involve analysis of various judgments of the Supreme Court. And it, in my respectful submission, if on merits your lordship is with me, then this would be an academic question as to whether that power is there. If only this honorable court comes to the conclusion that it is unconscionable, that this honorable court cannot sustain it, in that event, my lords, whether the power is there to modify will even be entertained or engaged. Not until then. On that point, my lords, my respectful submission is your lordship may only please see para 6 of my note. In para 6, I have extracted the minutes and I have highlighted what I believe are portions in bold which are relevant to the case. With the consent of the parties and learned counsel, therefore the parties and the counsel both agree, the fee of the arbitrators and expenses in relation to the conduct of the proceedings are fixed as hereunder. They are fixed. Each of the arbitrators shall be paid a sum of rupees 1.5 lakh per sitting and shall be shared equally between the parties, and they shall be paid an advance of rupees 6 lakh. My learned friend argued section 38 of the Act saying, at the initial stage, the arbitrators only fix an advance deposit. It is only at the conclusion of the award that costs are apportioned. The order here comes in two parts. Part 1 is what is the fee, and the fee shall be borne equally. The parties and the counsel both agree. And then a separate advance is also fixed within the meaning of section 38. Lords, and my respectful submission is if this is a plausible conclusion, even if your lordship believes that this may not be the only conclusion, the award could be sustained. He also uses the word shall be shared equally between the parties. And lords, my learned friend said they've paid secretarial fees, etc. They kindly see what's the thickness of that submission. It is 7,500. They are making it out as if they've paid a significant portion. Yes. And what's the last judgment? There are two judgments. What's on reasoning? I will not even read it out. There. That detailed reasons may not have to be found in the court, so long as application of mind is shown. This honorable court could sustain the award. In this case, the award says we have exercised our discretion, we have paid a lot of cost, therefore I am opposed. And lords, like I submitted last time, it is not as if I have not succeeded or my learned friend's client has not lost. They made an application which they lost. I made a claim which I lost. Therefore, the tribunal says apportion the amount. And lords, had also paid them 5 lakh rupees as advance. That also could not have been awarded because the tribunal came to the conclusion that there is no concluded contract. In those circumstances, it's the fairest. Now, my lords, in respect of the judgment that my learned friend has cited, there is one judgment of the Supreme Court in JG&G 2011 Supreme Court, 2 judge bench. 2006 McDermott is not referred to. NHI versus Hakim says McDermott is good law. And Supreme Court says one has to follow the oldest judgment. Oldest is McDermott, therefore JG engineers will not bind for that reason. Second, my lords, all other decisions and judgments of various high courts, they all trace back to Ircon versus Jivani, which is a full bench decision of the Bombay High Court of 2011. In 2017, NHI versus Hakim, Supreme Court says power not available. 2024 Part 3 SEC, Supreme Court reiterates that position. All judgment of the Honorable High Court may be powers in the interest of justice, may be laudable in object, but our judicial discipline demands that they cannot be. I'm so grateful.
Yes, there are two parts in his submission. One, the first part is where he says that the order of 27th August 2020 is basically an order under section 31A5, subsection 5. And therefore, after the disputes have arisen, the parties have agreed on how the arbitration fees is to be paid. That's his Miller's main argument. The second argument is, of course, Miller's where he relies on McDermott and the NHA Hakim judgment to contend that there cannot be a partial setting aside because it would tantamount to modification is what is essentially the argument is. And therefore, Miller's, that therefore my section 34 cannot be allowed. Now, on these two aspects, there's a recent judgment of Supreme Court, Miller's, on 2024. Actually, I believe it was passed in 2022. That's Miller's, it's a very long judgment. I have only placed the relevant part where it discusses 31A, Miller's. It runs to 200 pages, but Miller's, I'll tell you, Lords, what that judgment is about. It is about the determination of arbitral tribunal fees, whether the tribunal has discretion not to go by that schedule. So that's Miller's, that I'm just giving a copy. So in this judgment, Miller's, the court has drawn a very interesting distinction. This Miller's thing is coming from my So therefore, it makes a very interesting distinction between what is an arbitrator's fees and what is cost. Determination of fees is not determination of cost. Fees is always determined the initiation of the arbitration because the arbitration, then the tribunal tells the parties that this is going to be our fees. And then the tribunal passes an order under section 38, asking the parties to share the fees and make deposit. And if one party says that, if the respondent says that I'm unable to pay, then the tribunal will have no option but to ask the claimant to pay because it is actually at his instance, the arbitration is involved. Now just kindly have a look, Milods, at this, how the discussion starts at paragraph 92, Milods, and your lordships will find a heading, cost and fees, two different paradigms. And then your lordships will come to if your lordships may kindly come to paragraph 100, my lordships may kindly come to paragraph 99. Now lordships will see paragraph, there's a reference to a judgment of Supreme Court, earlier judgment, where it says, however, the learned in Gayatri Jhansi roadways, however, the learned single judge's conclusion that the change in the language of section 31D read with subsection section 31A, which deals with the cost generally and not with the arbitrator's fees, is correct in law. It is true that arbitrator's fees may be a component of cost to be paid, but it is a far cry thereafter to state that section 31A and section 31A would directly govern the contracts in which fees flow. I am not concerned with the second part. What I am concerned with, Milods, is the determination of fees is not under section 31A. Fees becomes a component of the cost. Cost is always determined at the end of the arbitration proceedings.
Yes.
When the tribunal will keep in mind all those various factors which I had, Milods, pointed out under section 31A, namely whether the respondent had filed, Milods, a counterclaim, what has been the conduct of the parties, and then the tribunal will apply its mind, and then Milods will ask the parties, because even the cost will include not just the arbitrator's fees, it will include, in fact, the expenses which I have incurred. My lawyer's expenses also will have to be incurred. So there has to be total application of mind when the tribunal determines what is the cost.
Yes.
Now please see, Milods, in this slide, just few paragraphs, and I'll then come to the order of 27th August. Milods. The above interpretation of this court is in harmony with the observation of Law Commission in the Law Commission's report, in the 246 report, which I had read out on the last day, wherein it had recommended changes to the regime of cost only to provide a statutory recognition to losers pay principle. And then this paragraph, Milods, I had already read, so I am not reading it again. Lordships may see, Milods. Yes.
Yes.
Lordships may next come to paragraph, Milods, 105. Sorry, 102. The concepts of cost and fees in arbitration must be distinguished. Fees constitute compensation or remuneration payable to the arbitrators for their service. Please mark this. Then, Milods, kindly come to paragraph 105. I'm not reading, Milods, the entire portion. I'm just reading the relevant parts. In 105, it says, in contrast, costs are typically compensation payable by the losing party to the winning party for the expenses the latter incurred by participating in the proceedings. And then, Milods, the reference is made to Salem Bar Association, the judgment, Milods. Kindly come to paragraph 106. The principle of payment of cost remains the same in litigation and in arbitration, even though form of expenses may vary. Redfern and Hunter on international arbitration has classified the various components of cost under the following headings. Cost of the tribunal includes charges for administration of arbitration by the arbitral institution. Cost of the arbitration include hiring and the hearing rooms, interpreters, transcripts, preparation, amongst other things. Cost of the parties include cost of the legal representation, expert witnesses and other travel-related expenditure, among other things. Then, the next page, the first category of cost of the tribunal includes the fees, travel related and other expenses payable to the arbitrators. So cost, the arbitrator's fees becomes a component of the cost. Cost is determined always at the end of the proceedings. Just kindly have, Milos, the next paragraph. 107, the purpose of awarding cost is to indemnify the winning party.
Yes.
The loser's principle apportions the cost between the parties through the core cost. Follow the event CFE method. The primary method of CFE method is to make the claimant whole. The CFE method has been statutorily recognized in some national legislations. The English Arbitration Act provides that unless parties otherwise agree, the tribunal shall award cost on the general principles that the cost should follow the event except where it appears to the tribunal that the principle is not approachable. Since costs are typically awarded at the conclusion of the proceedings on the basis of the relative success or failure of the parties, an award of cost forms a part of the final award. Please make this. However, interim awards or rulings on cost may also be issued. Please now come, Milos, to the next this paragraph. Kindly see, Milos, 109. No, just kindly come to this, Milos, 108. Most international arbitrations give arbitral tribunals the discretion to allocate cost unless there is an agreement between the parties. This has been noted. The loser principle is a common approach followed for awarding cost. Ancestral rules, while providing that cost of arbitration shall be borne by the unsuccessful party as a general principle, allow the tribunal to make the ultimate decision. The LCA rules allow the arbitral tribunal to depart from the general principles in circumstances so. The Arbitration Act also provides statutory recognition to the principle of loser's pay in section 31A2 as the general principle of allocating cost, which can be derogated from at the discretion of the tribunal, provided it records in reason in writing. Then kindly see 109. Further, the Arbitration Act seeks to limit the ability of the parties to contractually allocate the fees by specifying in section 31A5 that such an agreement will only be valid even if such agreement is made after the dispute and the question has arisen. So the parliament wanted this to be of some importance, that the tribunal applies its mind on the payment of cost. And in fact, even if the parties have agreed otherwise, before the disputes have occurred, the parliament has made its intention very clear that such an agreement will be of no effect. Please see now, Milos, 110. We can see the functional role of the cost and the fees is different. While fees represent the payment of remuneration to the arbitrators, costs refer to all the expenses incurred in relation to arbitration that there are to be allocated between the parties upon assessment of certain parameters by the arbitral tribunal or the court. Section 31A3 provides that an arbitral tribunal or the court has to take into account the following factors for determining the cost. Please see this. Another way to understand the difference between the, I'm not reading that portion, I had read out that section earlier. Another way to understand the difference between the cost and fees is to distinguish between the nature of the claim that both reflect. The Redfern and Hunter on international arbitration discusses cost in chapter 9 titled awards. It states that claim in respect of cost incurred by so-and-so by a party in connection with an international arbitration in principle no different from any other claim, except that it usually cannot be quantified until the end of the arbitral proceedings. The decision of the arbitral tribunal ordering one party to pay cost is considered as an award within the meaning of New York Convention and ancestral model law, since the decision resolves a claim one party has towards another in respect to the entitlement of being repaid by the other party for the expenses incurred during arbitration. Please see paragraph 112. Since the fees of the arbitrators are not a claim that needs to be quantified at the end of the proceedings based entirely on the conduct of the parties and the outcome of the process, they can be determined at the stage when the arbitral tribunal is being constituted. This is exactly what had happened in this matter. When the tribunal sat minutes on the very first date, it determined the fees. But that does not absolve it, the tribunal from its duty to determine the cost at the end of the procedure. When, my lords, while determining the cost, of course, the fees will become a component of the cost. And then the tribunal will apply its mind as to how all of these expenses, including the fees of the arbitrator and the expenses incurred by the other side, are to be apportioned by the kingdom. So there has to be an application of mind. Deviation is permitted only if the tribunal records its reasons for doing so. Now please see, my lords, in this slide, and then there are, my lords, on this, my lords, on the judgment, paragraph 114, Gary Born on arbitration. I do not wish to go into so much of detail, my lords, but I believe, my lords, if I have made up, my lords, what essentially, my lords, the judgment conveys. That there is a distinction between determination of fees, which is done at the inception of the arbitration proceedings, and a determination of cost under section 31A. Under section, yes, yes.
Where the award is next.
Award is?
Suppose the award, there is no challenge to the award as such. Only of the reason that costs have not been awarded. Right. And stated as should be.
Yes.
Is your contention that the award itself would become non-as?
No, not my contention. On that, Milas, I am coming to the second part of this argument. Yes. Yes.
Keep as a matter of fact.
Yes.
Award is
Yes.
sustainable as.
Yes.
But there is no interference or.
Yes. Yes.
What is the 34 code?
Yes, what the court is asking me is that is it permissible for the court to partially set aside a portion of the award and like an award on cost in this matter? That's what, Milos, the question is. I'm grateful, Milos. Please see, Milos, he has, for this purpose, he has relied on the judgment of McDermott and he has relied on the judgment in Hakim. Kindly see, Milos. Kindly see my compilation, which I had, Milos, handed over on the last day. There's a compilation, Milos, of judgments, which I had, Milos, handed on the last day. It starts with JG Engineers Private Limited in Union of India and another.
1 second.
Is that? I believe the court marked that.
Appeal 166. The compilation 166.
Yes.
Yes. Kindly see, Milos, the JG Engineers Private Limited, this is the judgment which I referred to, paragraph 25 of this judgment.
Yes.
Paragraph 25 of this judgment, page 18 of the compilation. It says it is now well settled that if an award deals with and decides several claims separately and distinctly, even if the court finds that the award in regard to some items is bad, the court will segregate the award on items which did not suffer from any infirmity and uphold the award to that extent. So if thus there are two claims, like a claim on the merits and the claim here the determination of cost. Cost is a part of the award. It's treated as an award. So if the tribe, now both of them have no inter-se relation. Therefore, where it is severable, the court has said that it can be partially set. Now please have, Milos, the next judgment, Milos, which I placed on record, because this is National Highways Expressway Limited versus Trichy Thanjavur Expressway Limited. This is a judgment of the Honorable Delhi High Court, Milos, of 2023. I cite this, Milos, judgment because it has noticed McDermott, it has noticed the Hakim, it has taken notice of ancestral, the various working committees report before the ancestral. All of that has been considered. Just kindly have, Milos, paragraph 2 and 3. Just to get, Milos, what is the dispute before the court and how the court deals with it. As would be evident from the release claim, Milos, page, the judgment should start, Milos, at paragraph page 21. Kindly have, Milos, page 23, paragraph 2 and 3, because this gives the gist of the dispute before the court.
As would be evident from the reliefs claimed in the two petitions, the appellants question certain parts of the arbitral award dated 7 August 2022. While 336 questioning of the part of the arbitral award dated 7th August 2022 to the extent it had rejected the claims amounting to INR 30 lakh so. National Highway Authorities of India seeks the setting aside of the arbitral award to the extent of the findings returned by it in respect of claim number 1B and Z as well as on claim day. Additionally, the petitioner NHAI moved an IA for eliminating signals. I'm not concerned with that. Please see paragraph 3. No, just see the last portion of the paragraph 2. The attendant question which arose and also so noticed was whether the grant of such a relief would be contrary to the decision of the Supreme Court in NHAI versus Kim. The Lordship has that. And which essentially held that power to set aside conferred by Section 34 cannot be read so as to include the power to vary or modify the award as rendered by the arbitral tribunal. Taking note of the importance of the questions which arose and the fact that any decision rendered on this the same would impact numerous matters pending or yet to be instituted, the court had published a notice calling upon the learned counsels to address the submissions. And then, Milos, your Lordship should see, Milos, the various submissions made by parties, Milos, from 24 onwards. And Milos, all these written submissions, Milos, I'm not taking your Lordship to it. Please have, Milos, paragraph 8, which your Lordships will find, Milos, at page 63. This is where, Milos, yes.
The subsequent judgment of the Supreme
Yes,
Court.
this one.
Yes.
This is for,
Yes.
not pari inquiry.
Yes, sir.
Pari inquiry, Milos, is where judgment of court. No,
No,
it's not binding. It is for a persuasive value.
Yes.
Because kindly have, Milos, in order to holistically evaluate the questions that stand posited, it would be profitable to briefly step back and recall the seminal developments and deliberations which preceded the adoption of the so and so. Milos, I'm not going into that in so much in detail. Your Lordships may kindly come to the relevant paragraphs, Milos. Kindly come to paragraph 30. Turning then to the development closer to home, we find that Supreme Court, while rendering its decision in Muhammad Hakim, had principally borne in mind the consideration the provision which stood embodied in the erstwhile Arbitration Act 1940, which included Section 1516 and enabled the court to vary or modify an award. It, however, found that significantly while promulgating the Act, no parallel provisions came to be adopted. It was in the aforesaid backdrop the Supreme Court in Muhammad Hakim observed as follows, and then Milos, the Hakim's judgment has been quoted in extenso. Please come to Milos, paragraph 31. It must be, however, be borne in mind that Muhammad Hakim was essentially concerned with the validity of the district and session judge announcing the amount of compensation as awarded by the collector in its award, while entertaining a petition under Section 34 of the Act. It was in that background that the Supreme Court observed that the only option available to the Section 34 court would have been to set aside the award if it was found to suffer from any of the infirmities prescribed in Section 34, and that while considering a challenge to an award, no power existed in a court to modify or vary the terms of the award. Milords, Hakim's case is not a case where it was argued that these claims are separable and therefore partial setting aside. It was a case, Milords, where the party had actually asked total modification of the award by seeking an enhancement of the quantum of the compensation award.
What was the finding?
Yes, please see Milords, paragraph 32. Milords, I'll just come quickly. I'm reading 3 paragraphs more and then I'm leaving it. As a preface to the discussion which follows, it must therefore be recognized that the question which calls for consideration would be whether Muhammad Hakim, while prescribing a modification of an award by Section 34 Code, should be read as an authoritative for the proposition that there can be no partial setting aside. while dealing with this aspect, we would have to bear in mind whether a conscious decision by the legislature. Now, Millards, I'm leaving that. Please come to Millards, paragraph 43. Page Millards 116. The Supreme Court in Muhammad Hakim, as would be evident from the passage of the decision extracted herein above, has enunciated the setting aside power as been equivalent to a power to annul or setting to not an arbitral award. It was essentially held that, bearing in mind the plain language of 34 coupled with the act having been desisted from adopting the powers of the modification or remission that existed in arbitral, the court, while considering its challenge against section 34, would not have the power to modify. The expression modify would clearly mean a variation or modulation of the ultimate relief that can be accorded by an arbitral tribunal. However, please mark this is very important. This is where it draws the distinction between the Hakim's case and these cases. It says the expression modify would only mean a variation or modulation of the ultimate relief that may be accorded by an arbitral tribunal. But when a section 34 court were to consider exercising a power to partially set aside, it would clearly not amount to a modification or variation of the award. Please mark this. It would be confined to an offending part of the award coming to be annulled and set aside. It is this distinction between a modification of an award or its partial setting aside that must be borne in mind. And then, my lords, JG Engineer was cited. So he takes notice of all these judgments, Hakim, McDermott, and Miller, JG Engineers. Now kindly come to Millards, paragraph 45 onwards, Millards. 46 after JG Engineer court cites Millards that Delhi High Court judgment. Then Millards it cites Millards at 47 Telangana. Yes. Yes. Telangana High Court Millards, Kerala High Court, Bombay High Court. All these high courts have taken a similar view that where it is severable, it cites all those judgments, Millards. And then Millards, your lordships will see at paragraph Millards 55. Viewed in light of the aforesaid, the learned counsel appear to be correct in their submission that Muhammad Hakim does not really deal with the question of a partial setting aside of the award. Please see paragraph 55. In fact, they appear to be correct in their submission that the partial setting aside may not amount to a variation or modification at all. And now Millards may come to paragraph 63. The body of the precedent that has evolved around the question that stands raised, as well as the authoritative text that we have had an occasion to review herein above, thus lends credence to our conclusion that the courts could resort to a partial setting aside of an award subject to the conditions noticed above. However, note that theoretically it may be permissible to view such decisions rendered by an arbitral tribunal distinct awards as in themselves. The complexities of the question which is posited arises from when one proceeds to consider the issue of a partial setting aside or annulment of an award in actuality. Even though an award may be viewed as, I'm not getting into that. So the court has said that Muhammad Hakim and McDermott, all these judgments which are not on the point where whether a partial setting aside can be done if the awards are completely, the awards on the claims are totally can be segregated. Now with this, Millards, I'll just come to the Millards. Now just Millards, kindly come to Millards, the compilation, the orders. I just wanted to show, but before that, kindly have a look at 38 first, and then I will proceed. Then Millards, I'll Millards take your lordship to those two orders.
Yes.
Section 38 says, Millards, it's about a deposit. The arbitral tribunal may fix the amount of the deposit or the supplementary deposit as the case may be as an advance for the cost referred to in subsection 8 of section 31, which it expects will be incurred in respect of the claim submitted to it. And then Millards 2 says, the deposit referred to in subsection 1 shall be payable in equal shares by the parties. And then it says, provided that where one party fails to pay his share of the deposit, the other party may pay that share. Now please see, Milos, the orders which were passed by the tribunal. Kindly see, Milos, the order of 27th of August, which my learned friend had referred to. With the consent of the parties, Milos, at paragraph page 52, Milos, of my Milos,
Yes.
with the consent of the parties, in fact, in his note also, he produced that. With the consent of the parties and the learned counsel appearing for either side, on either side, the fee of the arbitrators is that what is determined. And the expenses in relation to the conduct of the parties are fixed as under each pay of the arbitrators shall be paid a sum of 1,50,000 per sitting and should be shared equally between the parties, and they shall be paid in advance of rupees 6 lakhs to each of the arbitrators covering 4 sittings, including the present first sittings within the 4 weeks from today. The amount fixed is provisional and subject to revision.
Yes.
Now, all of these are orders, Milos, determining the fees, and is an order under 38(2). It does not amount to an order passed under section 31A. 31A subsection 8 very clearly says that the cost has to be, Milos, decided following the regime of article section 31.
Yes.
Just say,
I will never answer.
Which there will be no reply, please. Yes.
no doubt, my lords, in oil and natural gas, the court makes a distinction between fee and cost. If the tribunal's order had said each arbitrator shall be paid a sum of 1.5 lakh per sitting and shall be shared equally, if those words are not there, then it is only fixing the fees. Presence of these words means it is an agreement given in 5 minutes. Therefore, this judgment does not make sense. As 2 minutes. If your lordship will kindly see page 116 of my compilation, the referring order of the Honorable Supreme Court.
Yes.
Prior distinction between severance and modification is done away with by the Supreme Court. I will just read question number 1 and 2, and with that I will end. Question 1. Whether the power of the court under 34 and 37 include the power to modify. Question 2. If the power to modify is available, whether such power can be exercised only where the award is severable and the part thereof can be modified. In Supreme Court says severance is part of modification.
Yes.
No, it does not say.
That's all. I'm great.
Yes. Yes, that's it.
Milos, so great. Milos, this judgment refers Hakim because Hakim and McDermott is not a case under Milos the where severability was argued. Because of the subsequent judgments, the Supreme Court has referred.
Yes.
Great. I'm so very grateful. So great.
Wait. One submission.
She's raising.
In this one, serial number 24, it is not relating to promotion, my lords. It is for 24. Kindly accommodate day after tomorrow, my lords. It is for dropping of the contempt. It has been challenged, my lords. Maintainability. I little bit confused. Kindly have done day after tomorrow, my lords. Much.
ಯಾವುದು? ಹೌದಾ? ಅಲ್ಲಲ್ಲ ಗೊತ್ತಾಯ್ತು. ನಾನು ಅದು UTI ನಂಬರ್ ಕಳಿಸ್ತೀರಾ ಸರ್ ನನ್ಗೆ? ಹಾ. ಸರ್ ಇನ್ನೂ ಇದೆ ಸರ್ ನಮ್ದು. ಅಲ್ಲ ಇವಾಗ ಅದನ್ನ ಏನ್ ಮಾಡ್ಬೇಕು ನಾನು? ಇವಾಗ ಯಾರಿಗದು
அவ்வளவுதான். யாரும் பேச முடியாது. இவரு ஹோல்ல போட்டாரு, அப்புறம் கொண்டு போட்டாரு.
230 orders. Bill number 30. Subhananti.
Appearing with the counsel for the appellant, my lords. Last time the court gave us 4 weeks time to move to Supreme Court, okay, because matters are pending there. The counsel was handling the matter, has been designated as senior advocate now. So we have a problem of engaging a counsel and if I am again making a representation.
My lord, I
The
appeal for
matters
the
are all
respondent.
pending in Supreme Court. Your Lordship may kindly give us about 4 weeks time, my lord, we'll make necessary arrangements, my lord.
I appeal for the respondent, my lord.
What are the office objections? There
Those are,
appear to
my
be
lord,
several.
we have signed the settlements with the workmen.
On the
Those
previous
settlements
occasion,
have
an
been
order has,
filed.
on the previous occasion, my lord, an order has been passed in respect of the office objections. The office objections are in respect of memorandum of settlements that they have filed with individual workmen. On the previous occasion, this court has already said that those office objections will be taken up with the matter finally. This matter, my lord, was moved by me. What has happened, my lord, I've actually moved this matter seeking for it to be taken up for final hearing. Previously, my lord, an application had been filed seeking for certain payments to be made to the workmen. Those payments had not been made, then thereafter an application had been filed by me to vacate the stay. This court had said that insofar as that application is concerned, since the Supreme Court is seized of the matter in respect of certain interim directions that were issued, that may be taken up by the Honorable Supreme Court. My request is, my lord, this matter is in respect of a reference which was raised of the year 1998. The workmen are already quite old right now.
What is the subject matter?
My lord, the subject matter is an issue of permanency. They were all working as contract workmen. The order of the labor court was passed, directed that they be treated as permanent workmen, holding that the contract is a sham and a bogus. The labor court passed an award in the favor of the of workmen. Thereafter, the management challenged this in writ petition. Writ petition also, the learned single judge has passed an order upholding the order of the labor court. Unfortunately, my lord, none of the benefits have accrued to them because of the pendency.
We must consider the matter with regard to the position as it stood on the date of the
Please,
award.
my lord, please. I'm only requesting for a date to be fixed in this matter, so the matter may be taken up finally, my lord. That's all that I'm requesting.
Is it not the final hearing of the matter? They say that matter is pending before the apex court.
My lord, what is pending before the apex court is this. When the matter came up before this court, an order of stay was granted insofar as the award is concerned. And this court had directed them to make certain payments to the workmen. Those payments,
17B wages?
not 17B, my lord. An interim direction had been passed directing them to pay certain amounts to the, in the sense that to pay an higher wages to the workmen for the management to pay those wages. Then when those, when this was
There was never any question of retrenchment?
No, my lord.
No.
There is no question of retrenchment.
They were continuing as contract laborers or?
Please, my lord, they were
whatever, and-
continuing.
Yes.
And since there was when the award came to be stayed by this court also directed them to pay certain higher wages.
What is the date of the award?
The date of the award is 2012, my lord.
2012 award.
23rd August 2012 is the date of the award. So this court had directed them to make pay the workers wages at a particular rate. Thereafter, what had happened is that the contractor issued to the workers various notices of transfer. Those notices had been challenged by the workmen individually in civil suits.
Now, all
My lord,
of
I'm
the
only
workmen,
I'm sorry, my lord.
the workmen are out of service. They've retired.
No, my lord, they are not retired. They have not retired. So they had issued various orders of transfer. Those orders of transfers had been challenged by the workmen in the civil court, saying that since there is a finding that the employer is the appellant herein, the contractor has been declared to be a sham contractor cannot issue such a notice. The civil court, my lord, had passed orders of temporary injunction restraining them from acting upon the same. Therefore, thereafter, the workmen had reported for duty. They were not given duty. They were not paid those wages. This court had passed interim directions thereafter on an application by the union, directing the appellant to pay the wages to the workmen for certain periods, almost 1 or 2 years, my lord. Since those payments had not been made, I filed an application for vacating of the stay. This court was of the opinion that since those application, the direction to pay those wages for those 2 years, those were challenged by the appellant before the Supreme Court, my lord. So this court was of the opinion that since those applications are pending, the application for vacating of stay also could be held until the matter was disposed of by the Supreme Court, even though there's no order of stay by the Honorable Apex Court. My only request is that if the matter may be taken up for final hearing, there is no impediment towards that. Whatever happens in the Supreme Court is only in respect of the interim directions. ma'am.
Yes, what would you say?
My lord, may I make one submission, my lord?
Yes,
Though the award has been stayed, half of the factory was sold to somebody else. We did not require so many security guards. Therefore, some orders of transfers were issued, signed by contractor. They challenged it, saying contractor is not the employer. Then both of us signed. Because there is no work here, please go to my own establishment in other places. They have gone, refused to go. Civil court refused to give a stay. They came up to here. And this court said, no, there's a stay is operating. You are held to be a contractor. Therefore, you cannot issue order of transfer. You issue a fresh order of transfer. Then the matters were taken up in Supreme Court. Supreme Court has issued specific notice on the stay application. Unfortunately, we last time your lordships granted us 4 weeks time to move to Supreme Court. The latest order of this court.
no, that
Please.
again
Please
is
go to the
only with
lordship.
regard, that is only with regard to the interim arrangement. Can we list this on a date for a final hearing? Nothing stands in the way.
No, not at all. Your lordship may fix a date. I am ready to argue the matter.
Please,
List this immediate after Dasara holidays, give a date. On that date, please,
Please, my lord.
both of you, please be ready in the main matter.
yes, please.
Everything else would be incidental. Let's hear it on merits.
Most grateful.
Please give a date, 21st October.
Most grateful.
The problem is the council has been designated a senior advocate in Delhi. That is why we are in a disadvantage.
31, K. Krishna.
There appear to be office objections with regard to appearance of R3.
Appearing for R3, my lord. I filed a memo of appearance.
Were you appearing before the?
Before the
Learned
single
Civil Judge?
represented, it's an intra-court appeal, it's a continuation. That apart, my lord. No,
If his-
rules permit,
If he
my
has
lord.
entered appearance before learned civil judge, that will do. Yes,
It's a government official.
yes, office objection on the memo of appearance is overruled in view of the fact that a wakalat had been filed on behalf of R3 before the learned civil judge. Yes, and what else? Matter is to be heard.
It's been admitted. Appeal has been admitted.
Yes. Further, when can it be heard?
I need it.
Please give a date. Yes,
Next week.
immediately after Dasara. Immediately after Dasara holidays.
I leave
Yes,
some.
please give a date.
Okay.
Register may be directed to show correct my initial, it's shown a B, actually it is PV Chandrasekhar. I
Show
filed
the
correct
correct
memo of appearance.
Please show the correct names. Yes.
Any date?
22nd.
22nd October.
Please.
32 is K. Sudhindra.
I appear for.
Yes, week's time. We apply with the office objections.
33, government advocate.
My lord, I may be permitted to withdraw IA 1 of 24, IA 2 of 24, 3 of 24, my lord. I pray for 2 weeks' time to file appropriate applications and to bring the legal representatives of the deceased respondents on record, my lord. My lord, memo for dismissal of writ appeal copy is not served upon me at serial number 4. There is no, steps are already taken, IA 1 and now we're withdrawing and we'll file individual applications, my lord.
IA 1, 2 and 3 of 2024
Are withdrawn.
sought to be withdrawn by the learned government advocate. The memos are dismissed as withdrawn with permission to file proper applications. List
After
2
2
weeks.
weeks, my lord.
Yes, list after 2 weeks.
23rd,
30th.
30th. 30th,
Obliged.
34. Pass over.
Respondent is ready. We can pass it over. We'll take this up as the first item. Yes, pass over.
Thirty-five, Murgeshri Charity.
I appear for the respondents as well as the I have filed the, I appear for the contesting respondents as well as the impleading applicant, my lord. One of the family members was not impleaded in the pendency of the writ petition. I've sought to implead them as a party because they are also landowners. Is that objected to? The impleading? Hmm. Hmm. That is on the merits of the matter. You object to the impleading petitions? Yes, the impleading applications are not objected to. The impleading applications are allowed. Yes. Please. Is there any office objection to be complied with? No. They're all Yes. the, is listed on a day. Any date? No.
21st
Great.
October.
Great.
Thirty-six.
But I appear for
Yes,
respondents
Charity.
2 and 3, my lord. We have entered our appearance on 18th March itself for respondents 2 and 3. Our names has not been shown.
Yes, please show the name. Then what is English translation? Usual orders. Any other office objection? 47 days in filing appeal. Can it be condoned?
Notices.
Notice is not yet on.
Notice not on.
We have
Entering
entered-
appearance. He's
Yeah,
entering
but-
appearance, he wants
All
name
the-
to be shown for all the respondents.
Respondents 2 and 3, only
2
3
and 3.
respondents are.
Show the name of learned counsel appearing for respondents 2 and 3. State for respondent number 1, my lord. Yes, learned government advocate appears for respondent number 1. Can the delay be condoned and can it be posted to, having considered the contentions advanced and having heard parties? And in the light of the averments in the affidavit filed in support of the application, the delay of 47 days in filing the appeal will stand condoned. List for admission on. List on a date, near date. Yes.
23rd. 37, Abhinavar.
Third time after recalling. What is the office objection?
Delay.
Delay.
Not filed.
He's filed the delay application. This is the third time it's coming up after your order of recall.
But
Last chance, 2 weeks.
but the appeal may not be survived because my lord, the learned single judge referred the matter to the committee with the certain direction, my lord. The appellant already participated in before the committee and his application was heard and it was reserved.
The learned counsel shall also get instructions as to whether anything survives for consideration in the appeal in the light of the subsequent events. List after 2 weeks.
38, Suprasad.
Additional affidavit.
If may I have the matter next Monday, my lord, we'll file our affidavit. There is a direction to file an affidavit. By next Monday, we'll file, my lord,
Order dated 19/7/24.
19/7.
Yes. Time granted as a last chance to file the additional affidavits. List on some other day.
23rd.
Oblige.
39, Government Advocate.
Deceased R3. Pray for 2 weeks' time. 1 of 22. Continuation of delay of 100. That will have to await the impleadment. Yes, 2 weeks' time granted
40,
for taking steps.
Sachin BS. Await no.
For appellant minutes. For appellant, awaiting
Is there anything in R1 to R6?
R6 minutes,
Notice dispatched on 22/8. Await. List after 2
41,
weeks.
much or less.
Sauri HR.
41, 8 office objections. The calling of dismissal order was subject to compliance. No appearance.
42, Samit.
42.1 copy is not served on the state, my lord. Copy of the writ appeal.
Respondent must copies made directed to furnish the copies, appeal copies.
Please serve copies, counsel.
I'll serve the necessary copies, minutes. Minutes. LR application was filed. The
Hmm.
LRs have come on record, minutes.
Hmm.
I appeared for the LRs. 1004 I appeared for respondent number 4A and 4AB.
Hmm.
And 994 was writ appeal 994. I appeared for LRs of respondent number 5 in it.
The applications can be allowed.
Yes.
Yes, ma'am.
LR applications, so and so appears. Applications are allowed.
Maybe posted.
Copies, copies shall be served on the, copies of the appeal shall be served, appeal and connected papers to be served on the learned counsel appearing for the respondents. List after 2 weeks.
Post vacation, minutes.
Yes,
Maybe listed for admissions, minutes.
yes.
Obliged.
Much.
ಆಮೇಲೆ ಮಾಡ್ತೀರಾ ಕಾಸ್ಟ್ amendment.
Yes.
43.
I appear for respondent 9 and 10, my lord.
1 to 4 millard state government. 5 to 7 millard Yogesh D. Nayak millard represented before single judge. We have served the copy. His name is to be shown. Yogesh D. Nayak. 9 and 10 millard my land fund is representing. 8 millard is served unrepresented even before single judge. These similarly millard 11 to 13 also millard served before single judge. They are not represented because my grievance is only against 9 and 10 and also planning authority. Therefore,
That
millard,
he
that
is
may be
claiming-
dismissed with 11 to 13.
So we'll consider it on the merits of the matter without waiting for the rest of
Claiming
the.
easementary rights
to be served.
invoking Article 226, 227.
We'll consider it on the merits.
Please.
Are 11 to 13 may not be necessary?
They are, because he is also claiming their land also.
Millard, they are my neighbors. According to them, they will provide access road to my land. My grievance is against the planning authority. Without giving access road, millard, that is
Therefore,
grievance.
you will take the risk of not serving our 11 to 30.
11 to 13, millard.
You will
yes,
take the
yes,
risk.
yes, I will
Yes,
take it.
it is submitted by the learned counsel for the
The 8 served
appellant
unrepresented.
that the affected respondents are served and that our 11 to 13 were served in the petition and had not appeared. Notice, further notice to respondents 11 to 13 is dispensed with at the risk of the appellant.
And the
This
8
for-
millard served unrepresented. 8 also served
Yes, it is
unrepresented.
submitted that.
Then
Ah.
millard, 5 to 7 millard, Yogesh D. Nayak name may be mentioned and shown in this.
We show the name of. so it's-
Next week for admission, it can be taken up because it's not yet admitted. Notice only issued. my lord.
30th.
Yes.
30th.
Admission
For
on
me,
30th.
millard, I have no objection.
Yes.
Mhm.
Please.
44. Chokareddy. Or 3. Version.
Next time.
45. Harshita and Balkrishna.
Yeah, for the petition.
Maintainability.
Yes, my lords. My lords, it's order 37, rule 3 application for leave to defend was allowed without unconditional leave to defend was granted, my lords. My humble submission is that that in itself would amount to a final order passed and in support of my contention had produced a judgment of the Bombay High Court and which was further Supreme Court judgment I'm filing before this court today. The 37 rule 3 was
Yes.
Lords, by virtue of the order 37 rule 3 application of leave to defend being allowed without any condition when the defendant themselves have agreed that they are ready to pay 100% of the amount, that in itself amounts to a final order because now the suit has to go to trial, my lords. Therefore, I filed this present commercial appeal and in support of my contention, I producing a judgment of the Honorable Supreme Court.
What was under challenge? It's a commercial dispute.
Yes, my lords. It's a commercial dispute where the defendant has agreed to pay 100% of the amount. Therefore, I filed a summary suit. And there is an email where he says, I'm ready to pay. However, therefore, the leave to defend, even if allowed, ought to be allowed conditionally, my lords. This is a the judgment which I filed now is with respect to a similar application being filed, and the Supreme Court has laid down the criteria as to an order 37 rule.
Was
3
that under the Commercial Codes Act?
Yes, my lord, it's under the commercial courts. The appeal itself was filed, it was challenged before the High Court, maintainability was raised, and leave to defend was granted. Unconditional. This was challenged before the Supreme Court, and conditional leave was granted, my lord. Therefore,
Yes, list next Monday.
obliged.
46, Adinath.
This one office objection they raised regarding a seal to be put in the wakalat, my lord. Throughout, I have not put seal anywhere. That can be complied. I can file one more fresh wakalat, my lord. I can just argue the matter, my lord.
Yes, please comply with the office objection. We'll have it day after tomorrow.
No, my lord, the party is out of station. So I have to get one more wakalat and her seal. Only the seal is missing, which is not a important thing, my lord. Because throughout, she has not put any seal anywhere. It's only a signature what she has put. So that's not a criteria here, my lord, for an objection. In case it's required, I can file one more fresh wakalat with the seal. Whereas before the trial court, I have not put seal anywhere, my lord.
What is the subject matter?
In this, my lord, the contempt itself has been dropped. The miscellaneous petition has been dismissed by the trial court. Order 39, Rule 2A, my lord. Whereas even the evidence has commenced. Your lordship may kindly see the concerned order. That is at page 16. I'll just read the order, my lord. Page 17, it starts. Page 17, my lord.
List for admission tomorrow.
Please, ma'am.
7. Raghavendra.
Yes, maintainability.
Yes, ma'am. But an adjudication made by the court, commercial executive court, under order 21 rule 58 is an appealable order. Kindly see it's a decree. Kindly see order 21 rule 58.
Whether it is appealable under section 13 would be the question.
Yes, ma'am.
Appeal shall lie from orders passed by commercial division.
The
of
objection
commercial
is-
specifically enumerated under order 43 as amended by. Yes.
The office objection is under 43.
Mm.
It contemplates what are the appealable orders.
Mm.
An adjudication made under order 21 rule 58, it is not an appealable order. It amounts to a decree. Appeal should be filed. And appeal I have filed. Your lordship may kindly see order 21 rule 58, clause 4.
Yes.
Where any claim or objection has been adjudicated upon under this rule, the order made thereon shall have the same force and subject to the same condition as to appeal, or otherwise as if it were a decree. So, prior to 1976,
Yes.
prior to 1976,
Yes.
the position was different. Later on, cautiously, this amendment has been made, wherein, my lord, when applications are filed under Art 21 Rule 58, any order that is made would amount to a decree and an appeal lies. And there are judgments of this court also on that.
But proviso to 13(1)(a) says, provided that an appeal shall lie from such orders passed by the commercial division of a commercial court that are specifically enumerated under order 43 as amended and section 37. Yes. does not come under order. If it is treated as a decree, then will it be right? If it is a decree. But even if it is, it doesn't agree with. Agree by judgment or order of a commercial court at the level of district judge, there's an original jurisdiction, or a commercial division of the High Court may appeal, provided that an appeal shall lie from such orders passed by the commercial division or a commercial court that are specifically enumerated under Order 43.
Yes, ma'am.
You'll have to file a writ petition.
No.
If it is, if it does not come under 13(1)(a),
No.
have to be challenged in other means.
No, no. The order is passed by the commercial court.
Hmm.
As otherwise,
Hmm.
I would have filed a regular first appeal. Now,
Right.
this is a commercial court which has passed decree,
Correct.
and this order is made by commercial executing court. If it is passed by commercial executing court, I will come under order 13, what is section 13(1)(a).
1(a), it
Ma-
will not.
It-
You will not. Any person aggrieved by judgment or order of a commercial court at the level of the district judge, exercising original jurisdiction,
Hmm.
or as the case may be, commercial division of a high court may appeal to the commercial appellate division within a period of 60 days, provided an appeal shall lie from such orders passed by the commercial
Ah.
division or a commercial court that are specifically enumerated under Order 43 of
My
CPC
lord,
as amended.
no, no, here,
Hmm.
the court that has passed the decree
Hmm.
is located in Bangalore.
Hmm.
There is no other appeal.
Hmm.
So all orders, even though it is passed by civil judge, senior division, it
Hmm.
lies only to the High Court.
It will not lie to the High Court under 13(1)(a) is the difficulty. You can challenge it, but not under, it will not come under 13. That is a difficulty.
It comes
Not
under,
all orders.
yes, ma'am?
It may be an appealable order
Ah,
going by the provisions of the CPC.
yes.
But it's not an appealable order going by the provisions of Section 13.
Kindly see the section 13.
Yes,
Any person
yes,
agreed with judgment and order of a commercial court
yes.
below the level of a district judge.
Judgment and order.
Yes.
Yes. Hmm.
Below the level of a district judge
Yes,
may appeal to the commercial appellate court within a period of 60 days.
yes,
1A.
yes.
Any person agreed with the judgment or order
Hmm.
of a commercial court
Hmm.
at the level of a district judge
Hmm.
exercising original civil jurisdiction.
Hmm.
Here,
Correct.
civil jurisdiction, original jurisdiction has passed the order. As the case may be,
Not
the
exercising
commercial
original
division of the High Court may appeal to the commercial appellate division of that High Court.
Correct.
Yes,
Now provided, please read the proviso.
provided that an appeal shall lie from such orders passed by commercial division or a commercial court that are specifically enumerated under Order 43 so as amended by this court under Section 37 of the Arbitration Conciliation Act. Yes, even then.
It's a proviso, it will not. Even if you say that it has the force of a decree, it is not appealable under Order 43, and therefore an appeal will not lie under Section 13. Therefore, you can challenge it in other means. You can file a writ petition as against the order, not an appeal under, it is not a decree which is appealable under decree or an order, appealable under Section 13.
Kindly have it tomorrow.
Yes, next week.
17(9). 48.
48, I'm for the caveator minutes, caveator respondent. I have not been served with copy minutes.
What is the maintainability issue? What is the maintainability? No, it is a non-compliance. Yes.
Office objections I have been complied.
Please serve a copy.
I had been served the copy.
Yes.
No minutes.
I had produced the
It's
acknowledgement.
a factual dispute. We cannot.
Yeah, if I am served the copy, I am ready to argue minutes.
Yes, list it on some other day. Yes,
Only now they will file an execution where I am a tenant in this property earlier.
they have not filed execution as of now.
No, already
List it next year, next week. Yes,
tomorrow. Where urgency is, then they will execute the decree. That is the.
Executions are pending since 2 years, my lords.
boys. Yes.
Where
Mr.
first appellate court has passed an order, my appeal came to be partly allowed. In that view of the earlier execution will not maintainable.
It's on a near date. Yes.
Day after tomorrow.
When is the execution posted?
They had yet to file the execution proceedings.
They say they are,
They
oh,
are,
the execution now,
Has
new
been
they
fi-
have to file it. Yes, next week.
day after tomorrow,
Yes, 49.
Same.
Same,
49.
yes.
You'll take notice for R1 Alice. R2 may be dispensed.
R2
R2 is an arbiter.
can be, R2 can be dismissed.
In both the matters.
Yes, in both matters you take notice for R1. Council,
He is represented by KVA terminal.
Same.
Kevit. Yes,
50, Sampatye.
Team, my lord, I just want. It's an order, my lord, from the temporary injunction was granted, my lord, by the learned sole arbitrator. It was the expert order which sought, my lord, a vacating of that application. No, my lord, since there was no stay, my lord, the matter before the learned sole arbitrator reached to the arguments. We don't want to press this petition, my lord. I only request, my lord, a liberty may be granted towards all the, before the arbitrator in the appellate jurisdiction. With that liberty, it may be dismissed, my lord.
having heard the learned counsel for the appellants, this appeal is dismissed as withdrawn without prejudice to the contentions of the appellant and his right to raise the available grounds at the appropriate time.
Please, deeply.
51, Virendra Sharma.
Yes. Yes. The memo for withdrawal is taken on record. The appeal is dismissed as withdrawn. With permission to file fresh appeal in future. Yes, without prejudice to the contentions of the parties.
52, Virupakshaya, PH.
Integrity, my lord. Pray for 1 week to be granted, my lord. Pray for 1 week, my lord. And
Staff to
another is, counter is seconds, it is held on at 3/6/2024, my lord. 3/6/2024. Second set not filed, my lord. Part of June,
It has
I
been
have
filed.
filed, my lord.
Please verify. Yes, it's staff drawing.
Filed. Passed over.
Yes, there is the council on the other side.
34,
Item 34. Can we take this up? Heard you almost substantially. We'll hear the respondent and then come back to you if there is anything further.
Counter submission is a very much important. After he made submission,
Of course.
counter submission is very important for further proceeding. And before that, would like to submit one relevant judgment regarding a reappreciation of the evidence and entry filed by the honorable court in the disciplinary proceeding.
That we'll consider at the
Now,
time
one,
of your.
one judgment, madam, only one.
Yes. Yes, please place it on record. We'll hear you after he completes. Otherwise, this will not get over.
It is only affected the.
Yes, please make it available. We'll hear it. Yes. Are there notes in this or is it in my book? Thirtieth. Yes.
My lords, this, the petitioner was issued with the charge sheet
Yes.
on 14/2/2005,
Hmm.
mentioning various misconduct charges committed by the petitioner, my lord.
Hmm.
After issue of the charge sheet, my lord, the so cause notice was issued before the so cause why the charge sheet should not be issued. Then he went to he approached the Honorable High Court and the matter was heard. And in 2006, my lord, this Honorable High Court has also said that you can proceed with the proceed with the inquiry. And on the basis of that, again, that petitioner was requested to reply to the so cause notice. He has not issued a so cause notice reply. And 2006 onwards, my inquiry was commenced, my lord. Charge sheet was issued in 2005. And the statement of imputations.
Hmm.
Statement of imputation is issued in 2006, my lord. And this is already, the details are mentioned in the impugned order passed by this honorable court in the writ petition, my lord.
Hmm.
And after that, the inquiry was held, my lord.
Hmm.
After holding the inquiry, he was found guilty and he was imposed the punishment of removal from service.
14/2/2005, 14 charges were,
Yes, my lord. 14 charges were issued.
14 charges.
14 charges were issued and 31 documents were marked and one witness was examined on behalf of the management. And this inquiry was completed and he was found guilty and he was imposed with the punishment of removal from service.
Hmm.
It is 2006, my lord. That is and against that imposition of the punishment, my lord, he filed the writ petition before this honorable High Court.
Which is that petition?
That is writ petition number 1449 of 2008.
Hmm.
And the writ petition, my lord, that honorable High Court has come to the conclusion that charges are vague and that charges have not been proved. And then the honorable learned single judge has ordered for reinstatement in services.
Hmm.
And against that the punishment, my lord, this management has filed an appeal, writ appeal. Writ
504 of
writ
2020.
appeal number, my lord.
504 of 2020?
My lord,
Is it 504 of 2020?
not 2018, my lord. No, it's not 20. Against this order, my lord, that
Writ petition 1449 of 2008.
2008, which came to be allowed with the direction to the inquiry officer to commence the proceedings from the stage of from 4/3/2006 and complete the inquiry within a period of 3 months from the date of the appearance of the parties on 15/2/2012 at 10:30.
What is the date of that judgment?
That is, my lord,
Single judge 1448 of 2008.
that 4/8 which came to be allowed, that is on 3/2/2012.
3/2/2012. Which was the writ appeal as against that?
My
You
lord,
filed a writ appeal against that?
against this appeal.
Ah.
That I'll tell. And afterwards, my lord, that agreed by the said order dated 3/2/2012, the appellant filed a writ appeal, 681 of 2012.
681. Yes.
That said the appeal was disposed with liberty granted to the appellant to raise the question of payment of allowances and back wages, even if the preliminary challenge is to be dismissal. Since there was no stay, inquiry was proceeded with. During the inquiry proceedings, the documents were marked as exhibits in which the appellant had signed the inquiry proceedings. The appellant also cross-examined the management witnesses. Subsequent to the non-cooperation of the appellant in the inquiry proceedings, the inquiry was concluded holding him guilty of the charges. The disciplinary authority passed an order removing the appellant from the services of the respondent corporation on 11/7/2012. The appellant agreed by the imposition of the punishment on 11/12/2012, filed the petition 355019 of 2012. The said writ petition was disposed of by giving permission to the appellant to file an appeal before the appellate authority of the respondent corporation, and the appellate authority shall dispose of the appeal within 3 months, etc. The appeal is disposed of by the appellate authority while its order dated 23/2013 by rejecting the appeal. The appellant agreed by the above said order, filed a writ petition number 21936 of 2013. The learned single judge passed the order allowing the writ petition, setting aside the order of the termination and directing the reinstatement, continuity of service, and all consequential benefits. However, restricted the prayer of back wages to 50% and also directed to pay cost of rupees 25,000. The respondent corporation filed a writ appeal against the said order on 6/3/59 of 2017 before the Honorable High Court, and the Honorable High Court passed the order setting aside the orders of the single judge. The Honorable High Court, setting aside the orders of the single judge, remitted the matter to inquiry officer to proceed with the inquiry against the appellant from the stage of cross-examination of MW1. This writ appeal, my lord, is very important. Here, this is writ appeal of 72 pages. Here, this writ appeal, this honorable, the judges have came to the conclusion why the charges are not, charges are very specific and all, then it is not vague. They have given that the 4 paragraph, my lord, this orders passed by this learned honorable division bench, my lord. It is reproduced in the impugned order. I would like to read that 4 orders, my lord. Impugned order.
Yes. Yes. You are taking us to the impugned order first?
Impugned order dated 22nd March 2022.
Yes.
This is the order, my lord. Page number 56, my lord.
Finally, the,
Page number 66.
just a moment, just a moment. 6/8/2018, an order of removal was passed. That was the subject matter of both the writ petitions.
Yes, my lord.
That is WP 22131 of 2020 and WP 5559 of 2020.
Yes, ma'am.
Correct?
Correct.
Yes.
Yes,
That is
that
there.
was what was being considered.
Yes, my lord. Now,
Yes.
this order, my lord, this order of this honorable division, which is very important. Your lordship may kindly come to page number 56 of the order, my lord. Page number 56.
Till then, it is a recital of the facts.
Facts.
Hmm.
Okay, my lord. Then
Yeah.
after,
Can we start from paragraph 18 onwards? 18, page 55,
page 55, yes, my lord.
55. Yes.
55. The court, after examining the 14 charges as contained in the so-called notice from charge sheet dated 14/2/2005, has found that these charges were vague and has concluded that the vague charges vitiated the entire disciplinary proceedings. The court's conclusion in the regard is revisited in the aforesaid writ appeal number 6359 of 2017. The division bench has found categorically that the charges against the employee cannot be held to be either vague or unclear or without any supporting documents. The division bench finding is with reference to the certain specific charges in the so-called notice from charge sheet dated 14/2/2005. As illustration, it would be useful to refer the division bench conclusion in these regards. It was not the case of the petitioner that at any stage of the domestic inquiry or earlier to it, documents relied upon by the corporation in support of the charges leveled against him had not been furnished, and thereby it had occasioned failure in compliance of the principles of natural justice. Unless it is shown or established that the EO has placed reliance on a document which had not been furnished to the delinquent employee, it would not fall within the mischief of prejudice. Honorable Appellate Court in the case of the State of Textile Corporation Limited was P.C. Chaturvedi and others reported in 2005 AISCWO has held. The records reveal that copies of a large number of documents were supplied to the respondent number 1. Whether they were adequate for the purpose of taking a view in the disciplinary proceedings is another matter. But to say the relevant documents were not supplied is not correct. The High Court had attached great importance to the alleged admission of the documents for the purpose of adjudication on 8/10/1992. Though the ground was urged with great vehemence before the High Court, it is not disputed that what was accepted in the inquiry officer on 8/10/1992 was not only a document, but list of documents, books of the accounts of the portion of the respondent number 1 employee. It has been shown as to how the non-supply of this list caused any prejudice. The stand of the respondent was not additional documents had not been entertained, which plea the High Court had wrongly accepted. As noted above, no additional documents was brought on record, and it was the list on that same score the High Court view is clearly untenable. In this background, when the inquiry report dated 7/5/2012 is perused, it would disclose that in order to establish the charges level against the petitioner, the corporation had examined one witness, that is MW1, and through him, 31 documents have been marked as a exhibit amount to M31. The first charge against the petitioner is that he is incapable to hold the post of assistant sales officer, and on account of his inefficiency, and he had caused indirect loss to the corporation. The said allegation has been denied by the petitioner, and in his reply dated 16/2/2012, Annex N, he has stated at paragraph 1C with regard to shortage of sarees worth of rupees 18,049.30 paisa, containing that the corporation had blindly passed an order to recover the part of 9,024 rupees value of the shortage from the salary, and a learned single judge in writ petition number so had ordered not to recover the said amount and had accordingly disposed of the writ petition. He has also further stated in his reply at paragraph 1D to the charges containing that the shortage of rupees 4,103 had a notice while he was working in the Devata Market showroom. Though not attributable to him, he did not admit the right of a corporation to recover the said amount, as he did not challenge it, and the petitioner has contended that CM cannot be construed as a misconduct. The fact remains that he did not challenge the said order of recovery. In other words, petitioner had understood the allegations made against him by the corporation and also the documents laid upon by the corporation, which was delivered upon the petitioner himself in his detailed reply at paragraph 1A to 1E. And as such, learned single judge could not have arrived at a conclusion that the charge is vague. In fact, a corporation had imposed minor penalty of censure by order dated 26/2093, receipt of which is admitted by the petitioner in his reply dated 16/2/2012, submitted to the show cause notice, while paragraph 1E. Likewise, in respect of each of the charges as leveled by the corporation against the petitioner, it was sought to be sought to be substantiated by the corporation by relying upon the statement of witness MW1, through whom exhibit amount to M31 came to be marked, which was also duly replied to the petitioner in his reply. And being conscious of this fact, petitioner cannot be heard to contend that the charges leveled against him are vague. The learned single judge, while paragraph 21 has held that the charges leveled against the petitioner are vague, and thereby a petitioner had been deprived of his right to put forth substantial defense to prove the innocence vice vis with reference to the records, namely show cause notice dated 14/2/2005. The learned single judge in general has found the charges are vague, and in particular charge number 5 and 7 by way of illustration example. Hence, we have considered these two charges to examine as to whether these charges are vague. Consequently, the petitioner had been deprived of this right to put forth his defense, resulting in violation of the principle of net justice, and on the basis of such vague charges, findings had been recorded by the EO. The division bench has also found that the employer never contended that he was not issued with the necessary documents. The division bench, on examining the material on record, has also concluded that the employee, being conscious of the imputation of the charges, had replied to the charges and cross-examined the employee's witnesses. Therefore, the employee has submitted himself to the jurisdiction of the inquiry officer, whose report concluded in the dismissal order dated 11/7/2012. The division bench conclusion in this regard is extracted for immediate reference. Keeping these authoritative principles laid down by the Affairs Court in mind, when facts in hand are examined, it would emerge that a petitioner does not dispute the receipt of the show cause notice, come charge sheet, the affidavit of the corporation witness MW1 filed specifying the details of each charge and reply submitted by him to the charge sheet, and cross-examination of MW1 partially. Petitioner has never contended on account of vagueness of the allegations or imputation, he is unable to defend himself effectively. On the other hand, being conscious of the imputation of the charges, he has replied to the same, cross-examined the corporation witness, and thereby submitted himself to the jurisdiction of the EO without any protest. In these circumstances, it cannot be held that the charges leveled against the petitioner either being vague, unclear, or same being without any supporting documents. Hence, the findings recorded by the learned single judge in that regard have to be necessarily held as contrary to the facts on hand. Further, it is seen from the records that during the pendency of the writ appeal 3137/2012, the employee has served office order dated 14/5/2005, enclosing charges, statement of imputation, list of witnesses, and the list of documents. the employer contends that these documents are served to the employee through the office boy under the acknowledgement by the employee in writing. The employee relies upon certain documents to bolster the submission of his in this regard. In the light of the aforesaid conclusion of the division bench and a consequential remand for fresh documents from the stage of cross-examination to the employee's witness, the question for consideration would be whether it is open for the employee to contend either that the charges are vague or imprecise, or that the necessary documents were not furnished to the employee by the employer. It is undisputed that the employee's SLP before the Honorable High Court, Honorable Appeals Court is dismissed and the division bench order is attained finality.
Yes.
The court with the authoritative punishment in a writ appeal number 6359 of 2017 has attained the finality with the disposal of the SLP is of the considered view that it was not open for the employee to contend that charges are vague and imprecise. And that is the observations made by the single judge
Therefore,
with reference to that observations made by the writ appeal, my lord.
it could have proceeded only from the stage of cross-examination of the witness.
Yes, my lord. That is all.
Going by the direction of the.
Yes,
division
my lord.
bench.
Then, my lord, after this, my lord, then this, after this order, my lord, the bank, again, the corporation imposed the punishment of removal from service. Against the removal from service, my lord, he filed a writ petition. Writ petition number 53029.
Yes, 6/8/2018.
Same, yes, madam.
Just a moment. 6/8/2018.
In
there was
this-
again a termination.
In this writ petition, my lord, this honorable court, then what, that because the inquiry was not conducted and both the corporation and petitioner was not happy, he says that no, then we need to, because that inquiry and all these things now, we order for conducting the inquiry from outsider. Let the outsider conduct the inquiry. Throughout all this inquiry was conducted by the corporation inquiry officers, inquiry officer appointed by the corporation, outsiders. Then that both the parties agreed for conducting the inquiry, my lord. Then accordingly, this inquiry was entrusted to one retired judge, district judge. And he was appointed the inquiry officer. And that my lord, the inquiry officer commenced the inquiry. Here, my lord, the inquiry officer, normal inquiry officer's duty is to go through the charge sheet and come to the conclusion whether charges have been proved or not. Either there is a case of exoneration or the charge has been proved. Instead of this, what happened, my lord? Again, this before the inquiry officer, these issues was raised. No, charges are vague and all these things. The inquiry officer said, no, charges are vague and imputations of list of witnesses, document witnesses was not given. And hence, he advised the disciplinary authority of the respondent stating that you please consider this and then you initiate action as provided under law. In fact, my lord, as per the regulation, the charge sheet issued and statement of imputation, list of witness documents, everything was given. Now, whether charges are vague or not, that the division bench has really come to the conclusion charges are not vague.
Just a moment. Employee cannot notwithstanding observation about the petitioner's participation of campaign and conduct vague or not specific is not subject. Whether the employee is not participating in inquiry proceedings after the arbitration mentioned with the P 6359, therefore the employee must have the opportunity to file detailed reply. Furthermore, the question of the employee's right to monetary relief must be subject to the outcome of the proceedings. For the contention is that the division bench having held that charges are
Not vague, it is clear, and that is.
could only have the inquiry could have proceeded only from.
Exactly. That is what, my lord, that inquiry officer should have proceeded the inquiry, and he could have given, come to the conclusion whether charges are proved or exoneration, that whatever the findings, he could have come. But instead of that, my lord, in the beginning only, he says, no, 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 that the charges are not vague and all, that the disciplinary authority has to examine the matter and all. Against this order, my lord, that bank filed one writ petition. And that earlier portion stating that the corporation may proceed further and all these things, petitioner has filed another writ petition. Both the writ petitions were clubbed.
After the writ appeal judgment that we can consider also. We cannot consider go back.
Yes, exactly, my lord. Because that order passed by the honorable division bench was not challenged. That has attained the finality. That means so long as the charge as vague or not thing, that has attained finality.
Was as a matter of fact challenged. Was as a matter of fact challenged. The SLP was dismissed.
No, SLP not, on merit he has not challenged it. One application he has challenged before, because that petitioner request for time to that conduct the inquiry, that some time has to be given and all these things. Against that event, he is not on merits SLP. It is only on the IA, only SLP was rejected. He has not challenged this entire order before the Honorable Supreme Court, Appeals Court.
It has become final.
My lord?
That has become final. We cannot go beyond.
Yes, it has become final. It has attained the finality. That is what my contention, my lord. And that inquiry officer, again, that when the honorable division bench has come to the conclusion, inquiry officer cannot say, no, 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 this is vague, this is not vague and all this. It was not his duty at all. Inquiry officer is appointing the inquiry officers to find out he has to give the findings, whether charges are proved or not proved. That's all. But now, my lord, because now that half portion of the observation made by the inquiry officer, the corporation is challenged by petition 21, and another half portion that petitioner is challenged before this Honorable High Court. In this writ petition, what happened, my lord? That was the COVID time. Corporation has not filed the objection and all. And at that time, my lord, after hearing that, Honorable Learned Single Judge passed an order reinstating him in the service of the bank, stating that charges are vague, and again all those things he has mentioned and all. Against that one, writ appeal was filed before this Honorable High Court. Honorable High Court passed the order and remanded the matter back to the Learned Single Judge to consider the matter afresh. So that is why this impugned order is this. This impugned order is the order as in pursuance of the order passed by the Learned Honorable Division Bench, remanding the matter. This is impugned order, my lord. And after this, my lord, then after the impugned order was passed, and this that honorable in the impugned order, the Learned Single Judge said, because the inquiry was not completed by the inquiry officer, you conduct the inquiry. And you conduct the inquiry again. This inquiry was ordered to be the inquiry officer that respondent was directed to conduct the inquiry afresh. And this, my lord, then this that inquiry officer corporation started appointing inquiry officer and all. The petitioner filed one writ appeal. This is the writ appeal 347 of 2022. In this writ appeal, he challenged that because that even the Learned Single Judge is not in order in remanding the matter, conducting the inquiry and all these things, he has challenged. And in this matter, my lord, when this honorable division bench, my lord, after hearing the matter, then they said, no, 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 this inquiry is pending for a long time. The inquiry has to go on, and inquiry I permitted the corporation to proceed with the inquiry. And then subject to the condition that final order should not be passed without the leave of this honorable court. Accordingly, my lord, the inquiry was conducted and petitioner participated in the inquiry. He also cross-examined witnesses, and ultimately inquiry officer came to the conclusion that the inquiry he has been found guilty of the charges, and then he submitted the report. And then based on the report, that disciplinary authority has imposed the punishment of removal from service. But in the entire matter was, my lord, was done under the guidance of this, not guidance, my lord, as directed by the division bench. First, the division bench said that you proceed with the inquiry. Accordingly, the inquiry was proceeded. Then the division bench said, don't proceed further. Then whatever the inquiry officer report and all, you submit before the honorable court. It was submitted. Then we filed an application that kindly permit us to proceed further. This honorable court has permitted us to proceed further. Why? Pass appropriate orders based on this. Accordingly, the corporation passed appropriate order for dismissal. So now, my lord, this regarding, so this,
Yes.
now the punishment was imposed, my lord. Now, after imposing the punishment, my lord, your lordship may, because now these charges, the disciplinary authority, my lord, in a nutshell, they have given all these charges they discussed, and in the order of the disciplinary authority. I would like to read, but only 2 pages, my lord. Exactly what is that conclusion of the disciplinary authority, on what basis that. Proceedings, lordship, got it, my lord, proceedings of the disciplinary authority.
Where is it?
That is, it was submitted before the court, my lord. It is not there.
Along with the memo?
Along with the memo.
When? What is the date of the memo?
List of authority. Synopsis.
Synopsis ಇಲ್ಲಿ ತಗೊಂಡು ಬರ್ತಾರೆ.
Synopsis ಅಲ್ಲಿ ಇದೆಯಾ?
ನೋಡಿ, ಅದಿರ್ಬೋದು, ಹಾಕಿದ್ದಾನೆ ಕಡೆ.
Synopsis ಹಾಕಿದ್ದೀರಾ?
ಯಾವ್ದು memo ತಗೊಳ್ತಿಲ್ಲ.
What is your age of retirement?
62, my lord. 8/3/2006, I was terminated and termination order has been quashed by the honorable court. Thereafter, I was not reinstated to the service. They have not provided the SAT subsidiary alliance. Nothing has done, they have not paid to me. Thereafter, they conducted 3 termination order based on the baseless allegation and also the vague charges.
All the allegations are with regard to your earlier conduct?
Same charges, madam. Since from the date of 14/2/2005, even 1994, there is a division bench, there is a difference opinion. From that 1994 to till date, same allegations, same charges, same circumstance.
This stage, even now, instead of continuing with the inquiry, could you not settle the matter?
My-
The question is only monetary in nature. The question can only be monetary in nature now.
My lord, here in these charges, my lord, the lack of integrity, lack of devotion, then there's a lack of diligence, everything is involved. But in this case, in which case, my lord, because where the misappropriation, the inquiry officer says that misappropriation of the money, whether this charge is is it not a serious charge, my lord? Now everything is included here now. That is what I wanted to read, but your lordship is not getting this. My lord?
Every time you found, every time the inquiry finds against him, on some ground or the other, it has been set aside.
No, my lord, that appeal court did that quashed that order, stating that no, the setting aside is not correct in both occasions, that the division bench, the honorable division bench has quashed that order. That means what? That means it has reached the finality. That means whatever the order passed by the learned single judge was not proper. That is what is quashed in both the cases. When it is quashed, my lord, then we have to rely on that order only, that the appeal order only. And where is that single judge order will remain, my lord?
Then
Both the cases, that single judge.
inquiry conducted by you against him,
Yes, my lord.
which remains, Please show us. There is nothing, I don't see anything.
My lord, that produce my, I do not know that.
Where is the order
Wait.
say, where is the order which says that you can continue with the proceedings? Where is, on the basis of which interim order did you proceed?
Yes, my lord, that is. Your lords may kindly see that order passed by this honorable court, my lord.
When?
Paid I'll tell, my lord.
Well, yes, it's here. Just a moment.
Yes, my lord.
Yes. Yes, what is it that you want to take us to the inquiry report?
My lord, that inquiry, this honorable division bench has permitted the bank, corporation to proceed with the inquiry. And then subject to the condition that the final order has to be passed without the leave of the court.
Page 7. This volume. Yes.
There, my lord, that accordingly, my lord, that after conclusion of the inquiry, the matter was placed before this honorable division bench.
Yes.
And
please
division
tell
bench
us-
has permitted us to proceed according to the, as per the law.
Please tell us what you want to take us through in the inquiry. You wanted to take us through the
The
inquiry.
proceedings, orders passed by the disciplinary authority, my lord, that I wanted to take.
The finding in the inquiry.
Yes, my lord, findings of the inquiry officer, yes, my lord. Fourteen 12/2022, my lord.
Hmm.
Inquiry officer's report.
Regarding the inquiry report, my lord, so far I have not received any kind of inquiry report and any other further proceeding also, though the honorable court,
Produce here.
no, they have not, they have not, so
My lord-
far till now not received, I filed an
My lord,
application.
my
But-
lord, that I have filed on with this one, application before his honorable court stating that he refused to take. And ultimately, my in the open court, it was served, copy of that inquiry officer report and all.
No, my lord, the.
And this is a,
Let him speak, sir. Then thereafter, don't interfere when I'm.
no, I'm only talking, you just keep quiet now.
Please.
Yes.
The
My
counsel
lord-
of This court is arguing.
Yes,
sir.
I'm arguing that.
Please with the court.
Sorry, my lord.
Yes.
Apologize,
And
my
then
lord.
You were heard
Yes.
and nobody interrupted when you were making the submission.
Sorry,
Please wait.
apology.
Hear the response.
My lord, this is page number 13 is the inquiry officer's findings, my lord.
Yes.
The following charges are leveled against the DO as per the charge sheet dated so and so.
Page number 13 of the inquiry. report.
13 of the inquiry reports, my lord. 13 of the inquiry report. Inquiry report dated 14/12/2022.
Yes.
Lacks of capability to hold the post of assistant sales officer. Underutilization of the service of the sales staff on account of his inefficiency, resulting in causing indirect loss to the corporation. Showing dishonesty or fraud in connection with the business or property of the corporation. Acting in a manner prejudicial to the interest of the corporation. Willful insubordination or disobedience of the lawful and reasonable orders of the superiors. Negligence and lack of interest in the performance of the duties. Committing an act subversive of the discipline or the good behavior. Committing an act amounting to abatement of an act with amounts to misconduct. Making representations directly to various authorities, thereby divulging directly or indirectly official document or wrong information to the authorities detrimental to the interest and reputation of the corporation under the guise of ventilating his grievances. Committing an act resulting in loss of confidence and acting in a manner detrimental to the interest of the corporation. Resulting in marring the confidence and integrity reposed on him by the corporation. Criticizing the officers of the corporation, making allegation against the officers of the corporation, disregard to the reputation of the corporation and its officers. Poor performance in discharge of his duties throughout. Indulging in cheating the customers and not mending his ways in spite of issue of violence, thereby proving himself in incorrigible character. Height of inefficiency and incorrigible act exhibited throughout, thereby putting negative contribution, exhibiting a hatredness towards the officers of the company. The management has examined C. Ms. Chandrasekharaya, Deputy Manager, KSIC, Bangalore, as MW1, adduced evidence by way of affidavit, duly notarized dated 28/9/2022, and has identified as many as 32 documents which are marked as exhibit amount to M31. MW1 is its evidence, has classified the contents and exhibits charge wise for all 14 charges leveled against the DO. MW1 in his evidence affidavit for examination of N-Chief has stated that he was employed with KSIC and served the company for about 30 years, and that he retired from services with effect from June 2013. As the Deputy Manager, head office KSIC Bangalore, and he is well conversant with the facts of the case. Charge 1, that when the DO was working as assistant sales officer of factory showroom, Mysore during 1988, he was in charge of stocks, cash, and other valuable properties worth of 20 lakhs, and that he was required to coordinate with the superiors in the marketing division of the head office, and which is subordinate sales officer in the showroom in the interest of the company. that the performance appraisal report of the DO for the year 31/3/93 reveals that the DO was unable to take any constructive and positive decision. And when he was working in SSM Channapatna showroom, due to lack of proper supervision and coordination with his staff and inefficiency in a discharge of the duties, shortage of rupees 9,024.65 was noticed, which was also recovered from him as per the order dated 8/9/1992. When the DO was working in Devata Market showroom, a shortage of rupees 4103 was noticed, which was recorded in his salary in 15 installments and was severely warned by the order dated 8/2/1994. The DO was also issued with order dated 26/6/1993, imposing minor penalty of censure for having remained absent from the workplace, apart from preventing other staff from performing their duty. In support of this charge, the PO through MW1 has got marked Exhibit M1, Exhibit M2, and Exhibit M3. As regard charge 2, that the DO has a functioning as a sales officer, assistant sales officer in SSM Channapatna, raised a bill date on 21/9/1989 for having sold sari under Article 252A, wherein the first copy of the bill showed the price of the article as 564 rupees, but in duplicate and triplicate, the bill showed as 520 rupees 50 paisa. Thus collected excess amount of rupees 4350 from the customer, and for having cheated the customer, he was placed under suspension pending inquiry, was found guilty, and minor penalty of withholding of one increment without cumulative effect was imposed, and the period of suspension was treated as a leave, while orders dated so and so 17/6/93. That when the DO was working in Devata Market showroom, a theft of rupees 1,001 from the cash box was occurred, for which, though it was a serious matter, only the amount was recovered and no other penalty was imposed in order to give him an opportunity to improve his character. In support of the charge number 2, the PO through MW1 has got marked Exhibit M4, M5, and M6. That DO was in charge 3. DO was in the habit of leaving his workplace without prior permission and sufficient reason, and that he is also in the habit of addressing petitions directly to government in violation of the rules and regulation of KSIC, by which has caused damage to the reputation, the company and its officers. In support of this charge, PO through MW1 has got marked Exhibit M7, M8, M9, M10, 11, and 12, respectively. Charge 4. That when a DO was working as assistant sales officer in the Devata Market showroom, he was issued with a memo on 25/3/1992, failure to submit his sales remittance statement for month of January and February 1992, and that he was also issued with a letter dated 6/4/1992 and called upon to show cause within 7 days for not submitting the management information to head office on or before 3rd of every month. Also, DO failed to carry out the instructions of the deputy marketing manager, for which he was issued with a letter dated 33/1992 and so cause notice dated 29/12/1992. The DO offered the explanation but letter dated 6/1/93, but was not touched upon the points raised in the so cause notice stated above. In support of this charge, the PO through MW1 has got marked Exhibit M13, 14, 15, and 16. Charge number 5, that when the DO was working as assistant officer in a Mysore factory showroom, Channapatna SSM showroom, and in Devata Market showroom, shortage of fabrics were noticed and recoveries were made by issue of recovery orders against him. That also on account of DO's poor performance and misbehavior, probationary period was extended up to 31/3/1994, but letter dated 1/10/1993. That despite of opportunities provided to him, the DO failed to show any improvement. He continued with his negligent attitude and showed lack of interest in performing his duties. In support of the charge, he has identified and got marked Exhibit 17 and Exhibit 18. That the DO was in the habit of addressing petitions in the guise of redressal of grievances to government, and has made false allegation against Sri Philomena Raj, the vigilance officer, stating that he is a tainted officer. DO.
The charges are as stated in page 13.
Yes, sir.
Lacks capability to hold the post, showing dishonesty, acting in a manner prejudicial, willful insubordination, etc. Now, Are there any statement of allegations served on the officer?
The statement of imputation is there, my lord, along with the charge sheet.
When was it? No, it was not served along with the charge sheet.
Well, not along with charge sheet.
Along with charge sheet. So when was it served?
That is, it has come in the,
Unless that is served, everything that is found does not find a place in the charge memo. Unless the statement of allegations is served. Because the charges lacks capability, showing dishonesty, acting in manner prejudicial, etc. Has the statement of allegations been served on the delinquent officer? If so, when? Charge sheet isn't.
but it
It's
has,
on
a-
14/12/2005.
Ayo, these,
Say that a statement of allegations dated 17/2/2020 has been served.
no, not 20 mile, no, not 20 mile, that is after this fight. This, it was served in 2016. That is inquiry of, that impugned order of this learned single judge has mentioned, my lord.
Where?
That is what I read, my lord.
Where?
Page number 47. Whether the inquiry is based on the show cause notice charge sheet dated 14/2/2005 on or
7.
are both the show cause notice come charge sheet dated 14/2/2005 and the statement of imputation, list of witnesses and list of documents dated 14/10/2005. And this imputation is,
Obvious whether only show cause notice come charge sheet dated 14/2/2005.
yes, my lord.
Or on both the show cause notice come charge sheet dated 14/2/2005 and the statement of imputation, list of witnesses and list of documents dated 14/10/2005.
Yes, my lord.
Consequently, the employer terminated.
Yes,
That was
sir.
set aside, which was against which writ appeal was filed.
Yes, my lord. This is,
Again-
the imputation.
Just a moment. Paragraph 26, page 65. Paragraph 26 of the judgment. There could be some controversy about whether statement of imputation, list of witnesses and list of documents, a requirement under the KSIC rules is served on the employee. But after the impugned inquiry report, the employer has admittedly served statement of imputation on the employee on 17/2/2020, and the earlier statement of imputation and list of documents are part of the record. Therefore, the employee cannot, notwithstanding the observation by the division bench about the petitioner's participation in the inquiry as on that date, now contend that charges are vague or not specific. Further, employee has not participated. Therefore, there was a
My-
statement of imputation which was served on 17/2/2020.
No, my lord,
Where is that?
yes, my lord, this
17/2/2020.
2020, my what happened? No, my, yes, my lord, it is part of the record.
When you say it is part of the record, it should
Hello,
be available
my,
here.
my lord, before that, only one answer, my lord. This, the statement imputation was not served. This has come to the knowledge during the inquiry held by the outsiders, that Mr. that 2022. That inquiry officer says that where is the statement of imputation served? That representative of the KSIC, that corporation said, no, that it is not, he was not able to produce that. But in fact, it is already there. Then the court said that he said it is already there, but he was not able to produce it. Then the court that say that why you are not that given the statement of imputation. Then that corporation without knowing the fact that statement of imputation already served in 2010 only.
Statement of imputation that you have served. You say you have served one in 2005.
Yes, my lord.
He says you did not get it. You say on 17/2/2020 you served the statement of imputation. Where is it?
No, that's then against that he has given the reply also. That
Please
my
show
lord.
us.
Yes,
Say
yes.
it's part of the record. Please show us.
But your lordship is having the writ petition, my lord?
Yes, we are having everything.
Writ petition.
Your petition, your everything is there. Please show us where is the statement of imputation served on you.
Statement. That is the statement of imputation. He has sent the reply also, my lord. That 1 second, man. 1 minute, my lord.
Yes. So all we need to see is whether an inquiry has been conducted in accordance with the rules.
Yes, ma'am. That is true.
That is something.
That is all, my lord. And that
Must be convinced of. Please show us where is the statement of imputation.
yes, my lord. That.
Now, he cannot say that the statement is, the charges are vague because the division bench says they are not vague. Therefore, it may not be open to us also to consider because SLP has also been dismissed. But thereafter, whether the procedure has been followed, we can consider. For the present inquiry, whether the procedure has been followed, we definitely can examine. We cannot go
Well-
behind the charges because the division bench says charges are not vague. Therefore, we probably cannot go behind. But after that, what has happened, you need
My,
to tell
my
us.
lord, your lordship may kindly see annexure R8.
R8
R8.
in the
In
petition.
yes, my lord. Because here, R8, my lord. R8, page number 140.
140.
You're able to get, my lord?
What is not R8?
R8.
What is the amended petition?
Five 55559 of 2020. R8 is there, your lordship is able to get. R8.
Available? What is it?
Disorder.
That is the imputations, my lord.
This is
There, that competent authority also mentioned why it was unable, why it did not produce along with the charge sheet, that mentioned the details also, that mentioned, my lord, that.
Again, charge sheet 14/2/2005.
Correct.
14/10/2005, you say you serve a
Yes, ma'am.
statement of objection. Well and good, where is that? Was a copy. You are showing us an office order which says that there is a statement of imputations. You have conducted an inquiry now. All this must form of the inquiry.
Yes, my part of the inquiry, ma'am.
Your memo must be there, your statement of imputations must be there, all the 31 documents that are.
Yes, my lord, it is.
must be there.
But that I have read further, my lord, that all 31 documents are listed. And statement.
Will not do. There must be a statement of imputations which is served on the delinquent officer. Where is it? You refer to statement of imputations which have been served. If they have been served, please show us a copy. Why is it?
I'll show the copy, my, yes, I'll show the copy, because
Yes.
I'll show the copy, my lord.
Yes.
Yes,
Therefore, because the
I'll show the copy, my.
charges are generic in nature.
Yes, correct. Statement of imputation is important, correct.
Therefore, the statement of imputations has to show what are the allegations that are raised against him. It only says incompetence, inefficiency, dishonesty, etc., are the charges. Therefore, when the division bench says that the charges are not vague, we may not be able to go beyond it. We must see that a statement of
Yes,
imputation
ma'am.
has been.
Yes, my lord.
It's been given a proper opportunity to defend himself.
Yes, that is true, my lord. That is true. That is true, my lord.
As a matter of fact.
Yes,
the
yes.
purpose of that
That charge sheet, statement of imputation, list of witness, list of documents. This is a part of that inquiry. All these things should be there. That is there. It's,
Yes, because he states that the first statement of imputation was never given.
yes, ma'am.
That is his contention.
I'll just produce my,
Yes, some letter is there, but you still have not produced a statement of
I'll
imputation.
produce my tomorrow.
Yes, please make it available. If as a
Yes, ma'am.
matter of fact.
Yes, ma'am. I'll
the
make it available,
procedure
ma'am.
has been followed, we cannot.
Yes,
further-
I'll make it available, my lord. That is true.
procedure-
Yes, madam. That is
He
true.
has been given a chance to cross-examine the witness. MW1 has been cross-examined by him.
Yes, he was cross-examined. This inquiry was, this MW1, this inquiry was conducted in 2006. It was again conducted in 2012, again conducted in 2018. In all the cases, MW1 was there. And that he was cross-examined by the petitioner. It is there that I'll produce this entire record, my lord. That is the best, my lord.
Have been
Yes,
complied
ma'am.
with. What are the provisions of the rules? How was the inquiry to be conducted? The provisions of the rules have been complied with?
Yes, complied with. Provisions of the rule has been complied with by the corporation. That I'll produce my, that entire inquiry report only will produce my inquiry day to day. In fact, it is there, but I have not produced. I'll produce my lord.
Was his specific contention in the first place. We cannot go beyond the concluded proceedings. Therefore, the last finding in writ appeal number 3137 we cannot consider. Then writ appeal 6319 of 2017 also, beyond that we cannot consider.
Yes, my lord.
6317, if it is in your favor, we will have to.
Yes, ma'am.
stop
I'll
there.
produce my
We
lord.
can
That's
proceed only from there.
yes, that
We
is true, my
cannot
lord.
consider
Yes.
this. Understand, but even so, even if we are considering from the stage of writ appeal 6319, then the last inquiry conducted must be in accordance with the rules. He must have a proper opportunity to explain. Please, that much you must convince us.
My lord, this memo dated 4/1/2023. It is there, my lord. I produced the entire inquiry proceedings.
Yes,
Your
sir.
your lordship may kindly see.
Memo dated
4/1/23. This is serious.
maybe it's 23. Let's read through the. Team two. This is the 4126.
Ilwa.
No, we understand this is a long pending matter, several rounds,
My lord, just.
but that has to be made available.
Yes, my lord.
We must see how the inquiry proceeded.
Yes, that I'll produce, my lord, that having served that invitation to the other side, and that full entire inquiry proceedings also I'll produce before this court, my lord.
Imputation was made available to you as a. matter
Yes.
of-
Exactly, madam. So far, I've not seen any kind of imputation because they admitted that. It is
Oh, no.
clearly admitted that.
No.
Ma- No, no, 1 second, I'll submit only two.
20 was the imputation served on.
Now, imputation is based on unrelated xerox copies of findings, penalty imposed on the finding. Those documents they submitted before the inquiry officer has not considered. And
No, yes, my lord, I'll produce, my lord. That number, that document I'll produce.
no, madam. Till now, they have not served any statement of allegation.
My
Any
lord.
copies pertaining to the charge, it's 100% true.
And it was-
Yes, exactly, madam.
If it is that they have served on you,
It is exactly, madam. I'll.
Yes, my lord. Yes, my lord. Tomorrow.
But only thing,
Tomorrow or day after tomorrow.
on 17, after admitted the writ petition, again they issued one more Saukasha notice on the same old vague charges based on unrelated Jaras.
Vague charges we cannot consider. Now, because the division bench says it is not vague. There is a SLP file that is received. Therefore.
And thereafter they conducted.
Some charges in the charge memo, we cannot consider.
Yeah, my lord.
We are helpless as against.
No, no, again thereafter, again appointed, again order for the fresh inquiry with consent of both the parties appointed retired district judge as the inquiry officer. And during the inquiry, the inquiry officer order and directed to the disciplinary authority to show the proof whether the charges are framed on the basis of the statement of allegation or statement of, or recorded statement of witnesses relied upon the document by the witnesses. For that, they admitted that there is no document. The answer was negative. Instead, they submitted some unrelated documents, which is based on unrelated penalty imposed on the document. Those documents as not considered. Pertaining to this, in the division bench also observed that on the concocted document directed for inquiry, if necessary. So for a moment, my lord, kindly turn the page number 385. There's a writ appeal number 3878. 380 for a moment, my lord.
ನಮ್ದು ಕಾಪಿ ಇದೆಯಾ? ಇಲ್ಲ ನಾನು ಫೈಲ್ ಮಾಡ್ತೀನಿ ನೋಡಿ. ಎಂಟರ್ ತಿಂಗಳ ಫೈಲ್ ಇಲ್ವಾ?
Statement of allegations to the above said show cause notice dated 17/2/2020 is served by letter dated 17/2/2020, bearing reference number so and so on the delinquent official recorded in proceedings. The 17/2/2020.
Yes, my lord. I'll produce, my lord. I'll produce.
And
What do you want us to look into?
398, my lord. 398 para 2.
$398.
398 para 2, second volume.
Before the inquiry officer. Yes.
Madam, sorry, my lord. 399, page number. On the first page, IV Anuradha, again, I'll come to the, on the very same day, I held preliminary inquiry of the DO. In reply to the same, the DO submitted that he has received the article of charges, but he has not received the statement of allegations. List of document, list of witnesses in the support of charges made against him. He submitted that he has not understood the charges at all. He pleaded not guilty by denying the charges leveled by against him, but preferred to face the inquiry. He did not want to appoint any defense assistant for the present for his defense. In his inquiry, the proceeding implying that he would conduct the case himself. At the same time, the DOI has filed a memo inter alia stating that in accordance with the rule 26 of cases, conduct and discipline and appeal rules for short, within bracket. The disciplinary authority shall frame a definite charges on the basis of the allegation against the employee. It is further stated in his memo that the charges together with the statement of allegation should be served along with the listed document and list of document to the employee under the charge sheet. But according to him, the disciplinary authority has not served the statement of allegation along with the charge sheet and did not indicate the detailed description of clear, specific, definite, distinctive charges on the basis of the allegation and the listed document and witnesses specified in the charge sheet. Therefore, in this memo, he expresses that it would be difficult to understand the charges to take effective defense. At the same time, the DO in his memo, he has requested to direct the disciplinary authority to produce the list of relevant document and witnesses charge-wise specified in the charge sheet dated 14/2005, because he is required to verify the relevancy of the document to each of the article of specified charges in order to prepare himself to cross-examine the witnesses. Para 2, my lord. In the above circumstance, the disciplinary authority was directed to show proof whether the article of charges distinctly made along with the statement of allegation, the document relied upon the disciplinary authority, and the witnesses proposed to be examined on their behalf in support of the charges. In reply, the PO behalf of the disciplinary authority, produced another set of paper with the list of document contained thereof. The document produced with the list are the same document which are produced before me earlier. In a letter to the general manager of KSIC dated 1/1/2020, it is mentioned Shri Chandrasekhara, deputy manager, so and so will be management witness. Madam, till now, none of the witnesses not named also. There is no author of the document. Till now, I did not confirm the document, confirm that
Only one witness against, only one witness.
it's a management.
P. Chandrasekhara Iyer.
PM Chandrasekhara is not a witness. We can't consider us. For a moment, my lord, kindly consider the, my lord.
We'll consider, just a moment.
No, एक second. For a moment, my lord, kindly give it. In the,
Respondent is this.
My,
Has the inquiry been conducted?
yes, my lord, I understood, my lord. Whether the inquiry has been conducted as per the provisions of the, that is all I am out to prove, my lord. I will prove, my lord. That is only, with the documentary evidence, I will prove.
Before this has gone.
Yes, ma'am.
Now
But
we
and
have
regarding that
considered-
witnesses and all, my lord, that learned honorable division benches discussed at length, 31% documents were produced and one witness was examined. Anyway, this,
See, there is an
this I will
inquiry
produce, my lord. Yes, my lord. Yes,
Decided that he cannot now contend that the charges are vain.
yes, my lord.
Therefore, after that,
Yes, my lord.
whether the inquiry has been conducted in accordance with.
In
the
accordance with the
rules,
provisions of the, yes, yes, that I will be able to establish.
What
Yes,
are the rules? How has?
yes, my lord. Yes, yes, my lord.
my lord, for a moment, only 1 second, man. Page number 16, my lord. In page number 16 in written argument.
Please tell me what.
Yeah.
is it? Yes.
My lord, in case of Shivana D. Algur versus State Bank of Mysore, writ petition number 667 of 2020, High Court of Karnataka, decision has relayed as follows. In view of the finding on the base of the evidence of two officers who have no access to the petitioner branch, and two, those who have not worked with the petitioner and participated in the transaction in the question, their evidence cannot be taken into the, for the purpose of proving the case.
That we will consider. The interference by a writ court in an inquiry is limited to whether the inquiry is properly conducted or not.
Yes, that is a process.
We cannot consider what was the evidence, if there was some evidence, and if the inquiry was substantially properly conducted, that would be the end of it.
Exactly.
But which is why we are calling upon them to show us whether it was on the basis of served statement of allegations and on the basis of the rules in question that they.
Yes, yes, ma'am. I'll produce.
Yes, if it is, that would be the end of it, because we cannot go into the vagueness of the charges.
Exactly.
That
Madam,
has-
one,
As against you.
yes, Madam, one would like to say few words. Madam, in the charge sheet, there are certain charges are serious in nature. That is cheating to the customers and fraud in connection to the business.
Correct.
For that, my lord, there is no complaint, no name and no proof of loss to the corporation, no proof to the loss of gain the appellant. And if the respondent having such kind of documents, I'll be obliged whatever the honorable court imposing the penalty. My lord. After admitted the writ petition, again they conducted fair see inquiry and empty formality. In that inquiry proceeding also, the inquiry officer and the presenting officer admitted that there is no relevant document pertaining to the charges. The same extract copy has been produced in the written argument. For a moment, my lord, kindly shall I read, my lord? My lord, inquiry proceeding after admitted the writ. Further, DO files a letter dated 23/11/2022 with subject captioned above requested 26 documents in the first charge and 18 documents in the second charge out of 108 documents for 14 charges. Instead, furnishing the requested document, replied vaguely documents are not available without assigned any reason by letter dated 17/11/2022, seeking to exonerate him from all the charges. If the disciplinary authority is not willing to provide the requested document,
If any document has been relied on, of which copy is not given to you or shown to you, then that vitiates. Otherwise, if they rely only on the material that they produce before the inquiry office. And from that material, these charges stand true, that will be another matter.
Yes, madam.
Let us hear them on the.
And further, madam, and 1 second. And this document has been produced, this document has been questioned before the coordinate bench. The coordinate bench observed the concocted documents and order for the inquiry if necessary.
That we'll consider, yes. Yes, Learned, counsel for the respondent seeks to produce the records of the inquiry as also the statement of allegation, statement of allegations which are said to have been served on the appellant. When?
2 days, my lord. This,
2 days.
Thursday, Friday. Thursday, Friday, any day.
12th or 20th? When do you want it? 12th or 20th? He should also be available. When do you want it?
As court convenient.
20th?
Yes, my lord. My lord, I kindly make it part and please, madam. It is humble request, madam, pardon, madam, because I made 2 times argument.
20th we'll see. 20th, as of now, it is the same thing. 20th we'll see, if required.
Thank you, much
Yes.
obliged. And my lord, regarding the enquiry report, so far they have not served. The honorable court has directed, instead of furnishing the enquiry report, my lord, 1 second. Now, further, the even written submission also made. I requested to make passing the written enquiry report.
It is produced before.
No,
this court.
the court has been,
Want to challenge, you have to.
no, because they submitted to the court, my lord, might be, because so far I'm not aware of. Yes,
With copy to you, it is filed
my-
in the form of a
my
memo
lo-
with copy to you.
my lord, in the. Let him,
Yeah.
no, my lord, I'll make a submission on written argument also, same thing also, pride in that for quashing the IA.
Counsel,
And-
this is the difficulty. Party in person, please don't be argumentative. It was filed as an IEA with copy to all concerned. Copy is available with you. If you want a further copy, they'll. give it. You want a
Manada,
further
even,
copy?
even certified copy, Manada, giving the copy, how do I can challenge my lord? No,
Serve-
no, yeah, second, my lord, yeah.
Yes.
The certificate, without giving the certified copy, I cannot challenge before the honorable court or any court because that is not a genuine documents.
You have an inquiry report.
Yes, ma'am.
And even otherwise, inquiry report cannot be challenged. It's only the order passed thereon which can be challenged. We'll consider. Yes, Mr. Chandru, next day. Yes.
Lordship's kindly, serial
Well-
number 54 to 54.3. They appear for the respondents connected matters. There are 4 covered judgments of the Honorable Apex Court. I filed 2 memos to that effect.
What is the matter?
This is about the INAM's abolition under the INAM's Abolition Act. There has been the application is of the year 1958. The order of grant was made in the year 1999. Subsequently, that various proceedings have taken place, and on 4 occasions, the order of this particular went before the Honorable Apex Court, and on 4 occasions, they have confirmed the order passed by the Learned Deputy Commission. Filed a memo to that effect, 2 memos actually. Hello, on the memo, it may be heard, my lord.
Long with the memo.
Please,
There is,
any day.
My lord.
Any convenient date, I'm not insisting.
yes.
Serial number. My lords, may be permitted to make a mention, my lords. Serial number 58, my lords. A date may be fixed in the matter. My lords, urgencies.
Serial number 63 and 64, date may be fixed, my lord. Any date,
Serial
an
number
interim order
62.
may be extended, earlier granted.
Serial number 62, minutes, a BDA land acquisition matter where I submitted, they, state and BDA is in appeal, saying that they need my land for police station. On the last date of hearing, I had given a notification. Please, my lords, it's been, yes, my lords, on that short ground, I am arguing, my lords, and also the BDA is already withdrew.
Number 53, my lord.
Next week, one date, my lords, if I may take a chance.
Next week and all, let us see.
As
possible.
soon as possible.
Yes.
Serial number 53.
It
Roll
it will be.
63 and 60.